Yes,
Item 1. Item 1.
May it please your lordship.
What is that IA for
My lord,
appropriate order?
this is the case of a peon of a college. His case is this, that he is posted, appointed as a peon in the said college
When?
in the year 1997.
1997. Can you tell the date?
In the meantime, government has given, granted aid,
Aid is granted.
granting aid. It is a block grant. But his sole prayer in this case, that his grievance that he is not getting the salaries except the year 2021 and 22.
Where is your representation?
Representation is, my lord, I have filed a representation before the director of higher education.
Where is that copy?
My lord, is there annexure 9.
Annexure you have made that?
9.
Which annexure, brother? So you have been discharged way back in 2007.
My lord, from 2007.
You are not in the job now.
I am in job.
But you have written, I have been discharged from.
My lord, discharge means my lord, he was appointed as a in election duty. He was.
Where is your representation, brother?
Representation means, lord, it is filed there in the file for annexure 9.
Annexure 9?
My lord.
Most of it in I.
It's all right. Let us see the.
My lord, in the meantime, I have filed a miscellaneous application for a direction to the director to consider my representation. Because representation.
Give that. Petitioner has structured his prayer as under. First, now an application has been moved in IA number so and so, producing a copy of representation dated 5/12/2024, made to the Director Higher Education. Huh?
It is on your screen, sir.
Is that?
Yes.
Very done. Higher Education. At annexure. Education, seeking regularization of his services and for payment of arrears of salary, taking into account the granting need which has been accorded to the institution in question. Block granting need.
Block granting need.
First off, learned counsel for the petitioner submits that his client would be satisfied if a direction is issued to the director to consider the subject representation in a time-bound way. First off, learned ASC appearing for the respondent graciously agrees. Do you agree or not? To tell your client to consider this.
Yes, my lord. Subject to available that representation.
That's fine. Agrees to instruct the director to do the needful in respect of the grievance aired by the petitioner in the subject representation in accordance with law and in a time-bound way, if all contentions are kept open. First off. Next paragraph. In view of the above, petition is disposed of. A period of 2 months is prescribed for disposal of or considering the subject representation and to inform the petitioner in writing the result of such consideration. First of all contentions are kept open. It is open to solicit so and so. Web copy to be acted upon. No course.
That's why say if representation pending.
It is also open to before that. It is also open to the petitioner to give one fresh representation with all vouching material supporting his claim. All right, you give one more representation so that time will not be wasted in searching for the representation. Okay.
Your Lordship may fix a time.
Yes, 8 weeks. Within 8 weeks. Oh.
Item 2.
Next. Item 2. It is mentioned. You that?
Yes, sir.
Why all this jugglery in the circus in the prayer? Issue a writ of certiorari, quashing. No. Issue a writ of mandamus, directing to do, not to do. Over. Why I have to make jugglery, lot of circus to know what is the prayer? Supreme Court in one decision said, court should grant relief even if prayer column is absent. Because it's a writ jurisdiction. It does not depend upon the prayer. In fact, it is only, you take notice. Tax matter comes before me. Recovery of
motor vehicle tax matter.
Tax recovery officer. Anyway, you take notice and then tell whether it comes before me. Issue emergent notice, whether the AG request records of notice for who are the cost title, show the cost title. Yes. Emergent notice to OP number 5. Option. Post immediately after service. Next.
Item 3.
Yes, my lord. Petitioner challenge the advertisement as well as prayer for regularization. My lord, similar matter while issuing notice.
Issue notice. AG requested to accept notice for all private.
No, I responded OP2 to speed post.
OP2 is a inverse mail.
You are only for one.
One.
Emergent notice to OP number 2.
Speed post.
Any entry model is done?
Yes. Correct. I have corrected.
Entry model like this. Call along with WP number. So it also must be there just to do. Yes.
Item 4.
Petitioner is in a
One post is the result then.
No, they will go on process but no final decision.
Finalization.
Process was more than 1 year back.
Not similar.
If it is not already done. University can tell you. Yes.
Petitioner is an approved lecturer. While receiving all benefits, he has already been superannuated on 30th April 2025. But in the approval order, from the session it was approved in respect of the post of economics that was made 91-92, but it ought to have been 90-91. Thereby, 1 year notional benefits he will receive towards the qualifying service. For that purpose, recommendation at Annexure 8 is made to the opposite party number 1 by
College.
by the college authority. And after verifying that, yes, it is a recommendable case. And accordingly, pursuant to that recommendation, Annexure 8, the commissioner directed the director to submit a report. Still, it is pending. It has no decision has been taken, for which he has made a representation at Annexure 10 to the commissioner, and that may be disposed of. So that keeping in view the recommendation.
Regardless of the prayer column, comma, learned counsel for the petitioner submits that if his client's representation dated 3/1/2025, a copy whereof avails at Annexure 10, is directed to be considered in the light of college's recommendation dated 10/8/2018 and also the recommendation of.
And the government instructed the director second higher education to furnish a report. That is at this stage.
Also, in terms of
9 series.
Annexure 9 series.
9.
9 series. First one. The request column in the representation is as under. Page 11 or 41? 41, page 41. Request column, last paragraph. Well, next paragraph. Learned AGA on request appearing for the OPs fairly agrees to instruct his clients to look into the grievance of the petitioner as has been alleged in the subject representation in a time-bound way if all contentions of the parties are kept open. First off. With this proposal, counsel for the petitioner is also agreeable. First off. Next paragraph. In the above circumstance, same prayer earlier. It is open to solicit information, etc. Now, no cause.
And for opposite matter, 1 and 2, my lord.
1 and 2.
3 is the governing body.
3 is
Governing body, my lord.
governing body.
Governing
Recommendation is pending.
Repeat to send a copy of this order to OP number 3 by speed post.
My lord, yes, my lord. 1 and 2, my lord.
But one copy should go because
Yes,
you made
yes.
Yes.
Item 5.
Item 5, my learned friend has appeared for the caveator.
Let a copy of the requisition be served, madam. Not yet served.
Give copy.
Yes, sir.
Mira.
You can ask for a copy also.
Already given.
Next week we'll have that.
Madam.
Any urgency?
Urgency only, the IE may be also listed. That has not been listed in the list.
Registry to post the application in IA number. All pending application.
Only one.
14477.
14477.
Next.
Copy served, Your Lordship.
Item 6.
Yes, sir.
Item 6, my lord. My lord, petitioner is a student, my lord. My lord, in all the public documents, my lord.
Keep that, drag that mic before you.
My lord, petitioner is a student, my lord. So, my lord, in a birth certificate, my lord, her date of birth is appearing as 31/5/2007, my lord.
31/5/2007.
My lord. So, similarly, my lord, in Annexure, my lord, Annexure 1 series, in page number 9, the lordship, the date of birth is also similar, 31/5/2007, my lord. But in Aadhaar card, my lord, it has wrongly reflected at 27/5/2007, my lord. So it is creating difficulties in the academic career, my lord. So, my lord, it may be corrected only the prayer, limited prayer, my lord. So I have
the representation.
my lord, under Annexure 2 series,
Who appears for Aadhaar, that authority?
my lord,
Aadhaar cards, my lord, they are correcting it in the centers. Why the court will interfere in this matter?
No court, we have interfered because they will not do anything unless we direct them. That is the reason why citizens come here. They are like your government only, your officers only. You don't consider any representation till we say, till we threaten. Similarly, it is happening with them. I have seen in Karnataka.
my lord, since
Take notice, who is the authority whom you have made respond?
my lord, opposite party no 2 and 3, my lord.
One is
One is the
One is
secretary, my lord.
in the government.
Government, my lord. Opposite party number 2, Odisha Computer Application
AS
Center.
notice for one, emergent notice to 2 and post immediately after service.
Obliged.
Item 7.
May I please the lordship? The petitioner is a retired clerk of the retired high school, and as per the
Recipe matter.
yes, RSCP and grade pay, my representation is pending. Annexure 6. Before the authority, I ventilate my grievance to the director.
Consider the
Copy number 2.
representation.
Annexure 6
Petitioner
at page 24.
is grieving before the writ court as to non-consideration of his representation dated
19/6/25.
19/6/2025, a copy whereof avails at Annexure
Annexure 6.
6, wherein he has sought for sanctioning of pension with grade pay of ₹4,200 and also the arrears of RAC.
RSCP 1 August 15 to 31st May 2018.
during for the period between 1
August
1/8/2015
15
and
to 31st
31 May 5,
2018.
2018. When he retired, he having already retired from service on attaining the age of superannuation.
5 years.
First one. Next paragraph. Learned counsel for the petitioner submits that whatever amount is payable by way of RACP and consequent pension is petitioner citizen's property guaranteed under Article 300 capital A of the Constitution, and therefore that needs to be sanctioned and released to him in terms of subject representation. First time. This having not been done, comma, he adds, comma, intervention of rich court is warranted. Next paragraph.
And they have also considered in RTA Act, I have Annexure 4 series. They have considered in the district of Mayurbhanj and Baleshwar, but they have not considered. Yes.
For others, they have done.
They have done
For others,
Yes.
for others. This is a discrimination.
he also adds that, he further adds that in respect of others, similar benefit has already been accorded, as has been reflected in Annexure 4 series.
4 series.
4 series.
The district of Mayurbhanj and Sambalpur.
His client could not have been discriminated against. Next paragraph. Learned AGA, Mr. G, on request accepting notice for the OPs, in all fairness agrees to instruct his official clients to look into the grievance of the petitioner, as has been aired in the representation at Annexure 6, keeping in view the similarly treated cases that are mentioned in Annexure 4 series. First off, he puts a caveat that all contention should be kept open and that a reasonable period be granted by the court for such consideration. First off, with this proposal, counsel for the petitioner is agreeable. First off, in the above circumstances, same trial. Okay, like to solicit, etc., etc. Okay. Next.
Next is
And this is identical. The petitioner is also retired from service and serving as a junior clerk.
Representation is
Representation Annexure 5
Annexure 5 date
dated 23/4/2025.
25.
As per
Period is
period is only 2 months. 180/15 to 19/15.
115 to 19.
RSC. And grade pay of
Get pay of 4,200.
200. And similarly also in RTA Act, Annexure 4 series.
Similar cases are Annexure 4 series or
4 series.
They are good things. Yes. Next.
Item 9. 9, if I may please your lordship, my lord. My lord, after a series of litigations between the petitioner and the opposite parties, my lord, all of the litigations came to an end while judgments dated 17/9/2021. That your lordship will find it Annexure 1, page 16. The relevant part is at page number 30, paragraph 9.
Arrears of leave and encashment and salary,
Yes, your lordship.
pension, etc.
Yes, your lordships.
Not paid to you.
No, my lord.
From which date to which date you work?
My lord, my date of retirement is 31st January 2014.
2014.
Your lordship.
Since 11 years, they have not given anything to you.
No, my lord. My lord, that is what I wanted to brief your lordships. My lord,
Notice to.
my lord, notice to the Utkal University. My lord, I have one interim prayer, my lord. My lord, one Bipin Bihari Hota. He has been accrued all the benefits that I am also entitled to. My lord, let us file the call for. My lord, I only pray this in the absence of the other side because, my lord, they will play dirty. Let that file be called.
Let us. It's not that easy because everything is audited.
My lord, he has retired from the year 2006.
Anyway,
So his
that
file.
audit report will be available. They are all annually audited.
As your lordship
provisions
pleases.
of the Constitution.
I bow down.
Auditor General does that.
I bow down. Your lordship.
Controller and Auditor General. Issue emergent notice. AGA for?
Sorry, my lord.
AGA is party, not a party.
No, my lord.
Emergent notice. Returnable within 3 weeks. Yes.
My lord, I has also noticed, my lord, I have prayed for provisional pension.
Both on main matter and IAS.
Gratefully, Lord.
Item 10.
May I please, ma'am?
Yes.
So this matter relates to the appointment under rehabilitation assistance scheme. The petitioner's father died in harness in 2011, and in the same year, the petitioner has also applied. And in the year 2013, master list was published recommending the name of the petitioner along with the others. You will also kind of page 30.
For compassionate appointment.
Mild.
Then what happened?
My lord, master list was also kind of page 30.
No, sir, I believe you.
Yes, my lord.
I doubt you.
This in the master list, in the item number,
Your name appears.
in the serial number 30, the recommendation was made for the approval of the appointment of the petitioner on the ground of compassionate or on the rehabilitation scheme. But nothing was done since 2013.
2013.
So
Perhaps they want your client also to die.
and now
That's how governments work, na?
government has done many things, and in the year 2020 they made another rule, and that rule is not applicable. And in the your lordship kind have a glance
Take
at
notice.
page 43. My lord,
Let him take notice.
representation maybe
Consider.
yes.
In the light of Morayananda Sati case.
No, no, my lord. And I'm sorry.
Then you take notice and file object.
In this representation,
In his favor.
in Morayananda Sati, they have given another amendment. You also call it 43. 43.
In accordance with law, not in accordance with law, they have not considered. Otherwise, it will fend here for another 5 years.
I have given their orders in page number 39.
All right.
Mal.
But what I am telling you is,
Mal.
in the light of all that literature, if they consider
Yes.
your representation in a
Mal.
time-bound way, this way or that way, something will happen.
In terms of the Annexer 7 series.
They will keep everything in your in their view, and suppose if I give them 8 weeks,
Mal.
on 7th week rules are changed. You mean to say they should be ignored?
Now they have changed the rule. My
So
intention is
therefore,
they have
unless you have challenged the rule,
I
these
need not.
rules are not applicable is your contention.
My humble submission, I need not challenge because those amended rule is in favor of me. In my favor. Yes.
So it should happen in the light of amended rule.
Minor.
Okay. The short grievance of the petitioner is as to non-consideration of his application for compassionate appointment. His father having died in harness way back in the year 2011.
Man.
First, learned counsel for the petitioner submits that the apex court in a cateno of decisions has observed that applications of the kind should be treated on a war footing so that the distress of the family is mitigated. First, this having not happened, counsel submits, kindly be seated. Sit down, Prasanto. The intervention of this court is required. Next paragraph. Learned AGA on request accepting notice for the OBs very fairly submits that he would instruct his officials to look into the grievance of the petitioner as has been reflected in the petition papers.
On the annex
Keeping
9.
in annexure, more particularly
Annexure 9, ma'am.
9,
No.
keeping in view
The annex
the
7 series.
amended rules
Annex
by
7
notification dated 4 April 2025 at annexure 7 series.
Man.
First, however, he caveats that all grounds should be kept open and reasonable period be granted for consideration. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, identical order. Got the point? Okay. Open to solicit information, so and so.
Published.
11.
I think pass over.
11 is passed over.
Yes.
Okay.
Item 12.
Yes, sir.
But in this case, the petitioner is a trained guy, teacher, my lord, and claims promotion notionally to the cadre of a junior SCS.
The light of Dilip Kumar case.
My lord.
Dilip Kumar.
Dilip Kumar, my lord. And in time, my lord, Supreme Court, my lord, already recently, my lord, decided in Sudhaj Kumar Chaudhary and Kartika Das case, my lord. And confirming the order passed by the tribunal by the Annexure 9, wherein the tribunal has directed to grant the benefit to the applicant and other similarly situated person, my lord. And the government, my lord, went to this honorable court, my lord, and the case was dismissed, my lord.
SLP also.
And then SLP also dismissed, my lord. So now the principal, my lord, decided in Annexure 9, my lord, the order passed by the tribunal is confirmed, my lord. And I have already ventilated my grievances by the Annexure 13, my lord.
13.
13.
1-3.
1-3, my lord. Before the opposite corner 1, my lord. Stating all the facts, my lord, and to grant the same benefits, my lord, in view of the order by the Annexure 9, my lord. Now the same pending, my lord.
Petitioner, in his representation dated 16/5/2025, has made the following request. Last paragraph, last paragraph. Okay, page 67. Next paragraph. Learned counsel for the petition. Kindly be seated. Learned, Mr. G, if if you consider this, that will be sufficient.
My lords, all my lords, whoever estoppel acquiescence that is there also, that may be taken.
Contentions will keep open.
Kept open.
Yeah. Learned counsel for the petitioner draws attention of the court to the order of the Orissa Administrative Tribunal in OA number 3885 into bracket C of 2012. And ultimately, the affirmation of the said order at the hands of the Apex Court in SLP diary number 16580 of 2024 and 16586 of 2024 disposed of on 25/10/2020. First up, he submits that even though the tribunal directed sanctioning of similar benefits to other similarly placed employees, nothing has been done in that connection, at least as against his client. First up. Therefore, intervention of writ court is warranted. Next paragraph. Learned AG appearing on request appearing for the OPs, having resisted the petition on the grounds of estoppel, waiver, and the like, now fairly agrees to instruct his official clients, OPs, to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way and in accordance with law, subject to all contentions of the parties being kept open. First, this is appreciable. Next paragraph. In the above circumstances, same order, 8 weeks, all conditions kept open to solicit any information from the petitioner if need be. Okay. Next.
Item 13.
Well, a time may be stipulated.
8 weeks. No problem. Yes.
My lord, I filed seeking transfer of the election petitioner and conducted IAS from court number 6 to any other bench, my lord. And
Election petition.
yes, my lord.
Your party there.
I am the election petitioner.
You are the election petitioner. You have challenged whose election?
Respondent number 1, my lord.
Okay. Why it should be transferred?
Because, my lord, I have 5 incidents happened during the argument hearing, my lord. There is extensive bias, my lord, and the honorable court exceeded the acts and basically the chapter 3 and chapter XVI rules of the Orissa High Court. So also there is extraneous consideration. Evening, my lord, is very heavy heart. I am speaking, making submission that evening when I submit that I should be given opportunity. I am not given opportunity. And I would like to draw your kind attention on paragraph 40.
Can we do this way?
My lord.
We will keep this petition pending and we will direct him to dispose of your election petition in a time-bound way so that he knows that he is under the supervision of this court. Because the allegations which you are making appear to be serious. And I also understand difficulty of producing the evidence.
My lord,
Very difficult to produce evidence against the judges.
My lord, there is a proceeding, and I have requested the Registrar General of this Honorable Court to preserve the CCTV. My lord, can a judge of this Temple of Justice utter a sexually explicit, vulgar language to an election petitioner?
No, not only judges. Nobody should use bad language at all.
And it is there, it is in the court, open court, my lord. And when
You take notice. Let us see. This is your version. What other side will say, we do not know. So take notice. Then we'll take a call.
Yes, my lord. Tomorrow there is hearing. My lord, see the language. My lord, see the.
We'll request the judge not to hear the matter till next date of hearing.
Yes, my lord.
All right.
Yes, my lord.
But it is your petition. So it will be deferred.
Yes, my lord.
All right. Yeah. Issue emergent notice. Any official is a respondent? No.
Respondent number 1 is the other respondents are there.
Issue emergent notice. Personal. Copy of the petition shall be sent to presiding officer of the court. Who is that? Presiding officer of a court.
Court number 16, my lord.
Court number
16 16
of
Honorable High Court Judge.
here.
Yes.
My lord, that's what I wanted.
Yes, my lord.
You should go to Supreme Court.
My lord.
I do not exercise the jurisdiction.
My lord, this is-
judges. I was under impression that you were
Yes, sir.
making allegation against election petition before some magistrate, some
This is
civil judge.
application
No,
under
you cannot-
section 24 of CPC, which applies to High Court
My lord.
to transfer the cases of subordinate.
Can I pass an order against my brother? He will
My-
pass an
my-
order
my-
against me.
my lord.
Go for lunch today.
My lord, there is a particular section in the Representation People's Act, my lord. That section is 80A. The Chief Justice is the appropriate person.
To assign
Yes,
petitions.
yes, my lord. But fortunately or unfortunately, I tried to place this matter the
Just
registry.
anything if you want to say against the judges of this. 1 second.
Yes, my lord.
Yeah. All right. Number 1. Number 2, if you have any grievance against the judge, there is a procedure for that. This is not the way. This is not the way. I do not say you are right, wrong, etc. It's not in my domain at all. I was under the impression that the response, therefore I asked you whether the judge is also made a party. Generally, judges are not made parties because they enjoy protection under section 199, 98 of CRPC, old CRPC. Anyway, the best way is to approach other forum, not here. Otherwise, I am levying exemplary cost of rupees 1 lakh because you have made the petition. Unknowing, I will assume that you do not know the law. It's a concession to you. Such assumption is a concession to you because you are supposed to know law. You cannot make such allegations in a petition like this before another judge.
My lord,
Therefore, think about that.
My lord, it has to be placed before the Honorable Chief Justice, I suppose. But the registry for this, the office they said there is assignments and there is no assignments. So that's why there is only assignment. There is special assignment is to court number 25. They told me in the registry, my lord, who assigns. So it's supposed to be placed before the.
Having argued the matter for some time, now seeks leave of the court to withdraw the petition with liberty to pursue remedies elsewhere in accordance with law. Personal. Leave having been accorded, petition is dismissed as withdrawn with liberty as sought upon. Not happy with the order?
Thank you, my lord. But tomorrow is the date, so that
I do not. We do not know. We cannot make any in this one. After all, you have withdrawn the petition. In the withdrawn petition, I should make order. How can that? Yes, next matter.
Item 14.
All these three similar matters are covered by the judgment passed by your lordship on Lokanath Behra and others.
Have you given copy to where?
Copy I have not given. I have given a corrected copy. These judgments I am giving.
In the light of that judgment,
Your lordship passed this.
you have corrected the
Yes, I have
dates and other things.
Yes, I have corrected.
Take that. Read that. Both the matters. Three matters.
Three matters. And three matters in three copies I have
Separately
given.
out of that.
Yes.
Okay.
Obliged.
Yes, brother.
The matter relating to grant of headmaster scale of pay. Your lordship has the similar order. Only I have corrected.
Have
Item
you-
15.
Have you rectified your
No.
dates and other things?
No.
You that? Give a copy to brother also.
Yes.
You should always see, you should be very fair to the government advocates. Otherwise, they will be in a very disadvantageous position. The officials do not support and the bar does not support. How they should argue? Yes, brother, I have made similar.
Hello, only SLP number has been changed.
SLP number to be changed in that.
Yes.
What is that SLP number? Yeah, have you changed that here?
Yes, my lord, already I have annexed the copy.
No, have you changed it?
Yes, yes.
Yes.
Item 16.
Yes, my headmaster.
The father of the petitioner died in a road accident, my lord.
Certificate case.
Certificate case. Lordship only
2008 it is pending.
pending, my lord. That lordship kindly see the last page, my lord. The answer to from 2013, my lord. The last order was passed. Thereafter, no order has been passed, my lordship.
Because pages are not available today.
The page 32, last
What
order.
is this?
My lords, OSRTC is
The duty of the certificate officer to dispose of the case, my lord.
My lord,
Certificate may be a
Yes,
party,
we
my
have
lord.
prepared only order sheet.
Only orders.
See the
Your
date.
lordship may direct for
2013
early disclosure.
No, why we should why
My
can't I
lords,
call him here?
in fact, claim against OSRTC, that is a different entity, independent.
Claim against that is a provision 174, my lord. The certificate officer to for the recovery of the money, my lord. But since they are not paid the amount, I have filed the certificate case, my lord.
Right now.
The claim is against opposite party number 4.
No, that's a private party.
My lord.
He is the party, whatever difference.
Government corporation. My lord.
Government.
That is the government corporation, my lord.
Go to the prayer column. The short grievance, kindly be Vasanto. The short grievance of the petitioner is as to long pendency of certificate case number 79/2008 he being the dominus litis, that is pending before the sub-collector cum certificate officer. First, pending before jurisdictional. Learned counsel for the petitioner submits that right to speedy justice being a facet of Article 21 of the Constitution of India, long pendency militates against the idea of speedier justice, as observed by the apex court in a catena of decisions. And therefore, this code should direct the sub-collector to hear and dispose of the said case on a war footing. First. Next. Learned AGA Behra appearing for OP number 1.
3 minutes.
OP number 3.
1, 2, 3.
1 to
1 to
No, I am appearing for 1, 2, 3.
1. OP number
1 to 3. 1, 2, 3.
1, 2, and 3. And the private party is?
Private, no, that is a government corporation.
Submits that. The sub-collector happens to be an ex officio authority under several legislations, both state and central, and therefore some delay might have occurred in the disposal of the subject case, which is not that appreciable. First, in all fairness, he agrees to instruct the sub-collector to hear and dispose of this long pending case within an outer limit of
4 months, your lordship.
1 month.
1 month. 1 month. But he said within an outer limit of 4 months. First. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, the record of the proceedings only reflects a plethora of dates of hearing, as if it is a great case of constitutional amendment being challenged. First, for a petty case like this, more than 2 months is not required, whatever be the contentions. First, this court has been observing day in and day out such long pending matters which would affect the credibility of the litigants in the quasi-judicial bodies, like the answering OP here. First, learned counsel for the petitioner is right in telling the court that right to speedy justice is a constitutional guarantee, and therefore the direction has to be issued to the said sub-collector to dispose of the said case on a war footing. First time. Next time, in the above circumstances, this petition is disposed of, directing BOP number
3 minutes.
The sub-collector
to hear and dispose of the subject certificate case and report compliance to the Registrar General of this court within 30 days, reckoned from this day, failing which he may be summoned to court on an appropriate application being moved by the petitioner for taking suitable action. Okay.
My lord, copy may be communicated to OP 4, my lord.
OP number 4.
My lord.
registry to send a copy of this order by speed post.
Because they have to satisfy.
OP number 4, immediate.
Item 17.
It's item 17 and item number 18 minutes. Yesterday, a similar matter was there minute at serial number 27, that is WPC number 24414 of 2025 minutes, wherein your lordship was pleased to call for the counter minutes. The lordship
Issue.
Yes.
Mr. Mohanty, Lagnat AG, and sub notice for
Opposite part number 1 and 2.
1 and 2. Other
Notice. Opposite part number
subject notice to
Opposite part number 2. Yes, sir. Yes.
call along with WP number.
24414 of 2025.
Just write down it.
I'll definitely.
24414 of 2025. Next.
Item 19.
Next to 6, my representation details. 2825 matter pending before the opposite party number 4, that is the additional district magistrate from additional register of
To
society.
hand over responsibilities of outgoing executive committee.
Because there is a blatant violation of the guidelines of the bylaws and mismanagement of the funds, and there is financial irregularities in the society, my lord. And the ADM has the power, my lord, to take appropriate action, to make inquiry and use significant powers and responsibility related
Mr. Monty, take a call on that representation if necessary, or reject it. You can't keep representations. Receive that article 3.
Although it is a dispute of that Nagarika Mancha of a particular site. However, they have made a representation to the authority concerned on 2/8/2025.
Whether ink on the representation has dried up. Don't touch your representation. You may get your fingers polluted. 2/8. Today is 9/9.
Exactly. 2/8.
But in which matters you have disposed of the representations in time without intervention of the court?
It was received on 4/5. 4/8.
The short grievance of the petitioner is reflected in his 2/8/2025, a copy whereof avails at Annexure 6. First time. Learned counsel for the petitioner argues that when a citizen airs his grievance in writing, the jurisdictional authorities have to grant redressal to the same in accordance with law and in a time-bound way. First time. Next paragraph. Learned AGA Mr. Mohanty, having resisted the petition, contending that there is no right to consideration of the representation, now agrees to instruct OP number 4, OP number 4, to look into the said representation and pass appropriate orders that thereon within a reasonable time if all contentions are kept open. First one. With this proposal, counsel for the petitioner is agreeable. Are you agreeable?
Yes.
Agreeable. Okay. Next paragraph. In the above circumstances, the OP number 4 is directed to take a call on the subject representation within an outer limit of 8 weeks and inform result thereof to the petitioner. First, it is open to solicit information, documents from the petitioner if so exercised. No course.
After giving an opportunity of hearing to the petitioner.
This part of the saying, after giving an opportunity of hearing to the petitioner.
So all the stakeholders, because the other side is
the petitioner and other stakeholders.
Exactly.
Item 20.
The grievance of the petitioner to correct the father name from Chandrasekhar Giri to
Chandrasekhar Giri.
Yes, one H.
Chandrasekhar Giri.
Yes, madam.
H has to go.
H has to go. My land school already refer annexure 5 series to opposite pattern number 3.
Who appears for OPs? Dev International School.
That is opposite pattern 4 and board and CBS.
Take emergent notice.
Yes.
Huh? Emergent notice.
Lordship dispose of Union of
UI. But notice has to go to them, na?
The school already referred my lord.
Ah.
In DAB private school.
Private school. Indian Central Board, CBS.
Notice has to go.
Should dispose of
How?
unnecessary school refer my unnecessary file.
It's all right, but you bring at least some central government lawyer. You serve copy first.
Yes.
Okay. Issue emergent notice, returnable within 10 days. Okay.
Today I passed. Today passed.
Why today? This is not a bakery where you will have the cake immediately after going and standing before the baker.
Just one date may be fixed.
Within 1 week. Immediately, returnable within 1 week. Okay. Post immediately after service. Grievance is involved.
May I please, let's say.
Yes.
My lord, kindly a glance to page 77 of my brief.
What are those annexures 6 and 7?
My lord, these are the state government wants to establish Shisu by Appellate Sebikaj, engage Shisu Sebikas in the Shisu Batikas open throughout the state now. There I agree, because we all the petitioners, my lord, are the diploma in early education, childhood care, education, trained teachers. Why I am bringing to my lords to the National Education Policy 2000, that should make kindly a glance to page annexure 3, page 77.
You take notice, file objections, because similar matters we treated we admitted in Karnataka High Court. Similar matters. Just look into all that. Issue emergent notice.
I am appearing for the OP1 minus
So and so appears for OP number 1. Learned AG appears for
2 and 3.
2 and 3. No other private party.
No other private parties. My lord,
All after 2.
why I am humbly submitting my lord? That's it. For a moment, kindly a glance to annex.
I will not grant any interim order in matters like this. Let them file objections. Then matter will come. Nothing will happen.
For a moment, my lord, let's hear me kindly. My lord, for a moment, let's see kindly a glance to page 85 of the brief. My lord, two things I brings to my lord's notice, which procedure has not been followed by the state government here. Page 84 of the brief, my lords. Let's have got it, my lord.
There are one early childhood care, etc.
My lords. Clause 1.4, my lords. The overarching the goal will be ensure universal access to the high quality ECC across the country in a phased manner. Special attention and priority will be given to the district and locations that are particularly socio-economically disadvantaged. ECC shall be delivered through a significantly expanded and strengthened system of early childhood care education institutions consisting of A, standard of alone Anganwadis, B, Anganwadis co-located with primary schools, C, primary school sections overcoming at least 5 to 6 years of co-located with existing primary schools, and D, standard alone preschools, all of which would recent workers, teachers, specially trained in the curriculum and pedagogy of ECC mallards.
Pedagogy.
Mallards. Then last week skip out to paragraph 1.6. It investigated that prior to the age of every type of child to move a preparatory class or Balbatika, that is before class 1, which has a ECC qualified teacher. This is must, my humble submission is which has an ECC qualified teachers. The learning in preparatory classes shall be based preliminarily on the play-based learning with a focus on the developing.
We'll see. Let them file objection.
May I kindly have a glance to them. Why I am submitting my lord?
No interim order. I reject that interim order.
No, my lord.
Therefore,
my humble submission, my lord. In all schools through the state, they have opened the Shisu Batikas, my lord, but going to open Shisu Batikas was no training education.
Next week we file objections. When the policy says only trained and qualified personnel.
What he says is not the correct version.
Anyway, you file objections.
Yes, I'll file
it requires objections. Okay? Learned AG is requested to accept notice for all respondents.
For OP number 1, my land Union of India.
And all other respondents are represented by magistrates. AG for other respondents.
We are for 2 and 3.
2 and 3. 2 and 3.
And my Lord, and senior to take instruction, it's any of the schools, have there is a CC teacher.
Let us see.
The Lordship call it after 10 days.
Call this matter. After 2 weeks, we will call this.
Yes. Problem.
In the meanwhile, you have to file your objection.
Yes.
In the meanwhile,
For a date balance.
counter to be, no date will be fixed at the admission stage. Right now, unless it's to extreme urgent matters. To file statement, counter failing which right to file one stand forfeited and petition amendments may be taken with face value. Yes, next.
Item 22.
May I please?
Yes,
Here, my lord, the annexure
7.
5 is the order impugned, my lord, where the collector appellate authority has confirmed the order of the estate officer, my lord. Admittedly, my lord, I am in occupation of a small patch of land, that is a government land, and proceeding was initiated. Like me, my lord, other persons have been possessing the land. But so far as the present petitioner is concerned, my lord, that proceeding is against the present petitioner, none others, my lord. And during
Dacoity is defined by Macaulay. Robbery is also defined. Difference is for offense of dacoity, there should be more, 5 or more.
5 or more.
Suppose out of 5, only 1 dacoity is caught held by police. Can he say, no, you have not arrested other dacoits?
No, that is.
You are dacoit of government land.
Yes.
And government wants to take that robbed item. They are taking that in accordance with
that recourse has been taken.
Yes.
And there is a provision in such act, my lord. During proceeding, evidence is to be adduced.
Where is the question? You are admitting that you are in unauthorized occupation.
And there is no provision for settlement of that land in such act, my lord. But the other provisions, other acts are there, my lord. Those who are in possession of the government land, they can claim for settlement of that land.
But under that act, it is not. This does not come under that act.
No, my lord. This is particularly confined to that Public Premises Act.
PPP Act.
Yes.
Yes.
And you will also may kindly glance that section 7, holding of inquiries, my lord.
Where is the question of holding? You admit that you are the unauthorized occupant.
Yes. That's why, my lord, that the legislature has incorporated such act, my lord, in order to make a proceeding, my lord.
Proceeding.
In such proceeding. Yes, exactly, my lord. In such proceeding, my lord, certain procedures are there.
Now, you are admitting that you are in unauthorized occupation of the land.
Yes.
If you seek some time, I will grant. Otherwise, I will dismiss this petition with courts. You are the robber of the government land.
Yes, sir.
And the state, there is a provision, state act is made.
Yes.
Where is the question of procedure? You admit that you are the unauthorized occupant.
Yes. For on
that was disputed. Then other things will arise.
Again. Yes.
If you seek time, I may grant, provided you undertake to vacate the premises.
Your Lordship may kindly see page 40, appellate authority order.
Yeah.
Page 40, second paragraph.
Page 40.
40, the second paragraph. Yes, in the middle. The encroacher, that is the appellant, has illegally encroached the government land by constructing a 3-storied hotel, namely Utsav. The appellant is not a landless or a poor person, rather he is a wealthy trader having coal business.
Yes.
He's not a landless person.
Yes.
And he's doing a hotel business there. That is the finding of the appellate court.
Next week, my lord.
Nothing like that. No installment hearing.
Yes. Only my submission before your lordship that they have stated that there is no inquiry, my lord. Yes. Absolutely, there is no inquiry.
Dismissed. In terms of paragraph 2, numbered paragraph 2 at page 40. With a cost of rupees 1 lakh. Payable by the petitioner to the state exchequer for remaining on the government land unauthorizedly.
I am withdrawing, my lord.
Running there. You want to withdraw?
Yes, yes.
Learned counsel for the petitioner, having argued the matter vociferously for some time, now seeks leave of the court to withdraw the petition. First off, leave having been accorded, petition is dismissed as withdrawn with no liberty to agitate on the same cause of action. First, a copy of this order shall be sent to all the respondents by the registry by speed post before sunset of the day for taking appropriate and speediest action in terms of impugned orders. Okay. Yes, next.
Item 23.
May I please, Your Lordship? May I please, Your Lordship?
Yes, sir.
Let's, the present petition is passed out from the National Law University and a BA LLB honors course, my lord.
Yeah.
My lord, the with highest CGP holder and rank 2, my lords. But the convocation is going to be scheduled to be held on, my lords, the 13th. But as per the criteria, gold medal, my lord, they have not, my lord, the awarded because I make a representation before the authority. Since, my lord, the 29th August and 31 August, my lord, but they have not responded to anything, my lords.
You are entitled to a gold medal.
Yes, my lord. Lordship, may kindly for a moment, my lord. Rule.
Criteria.
Rules, my lord. The page 65, 2020 rule, amendment rule, my lords. Page 65, 29 clause, my lord. Academic honors. That's got it, my lord.
65. Rule.
The rule, my lord, 29.
Academic honor.
Yes, my lord. The 2.2. Those shall
award gold medals.
Yes.
My lord, outstanding performance to students from the outgoing batch. They shall include the gold medal for the highest overall CGPA. CGPA is cumulative grade point average.
Yes, bro.
As well as the best performance in individual subjects. Students who have appeared in a repeat or will not. And you are the highest scorer.
Yes, my lord. The page 71 and 72. Lordship, may kindly for a moment. 71, my lords. Number 1. Roll number. Name. Abilis Samanti. Then, my lord, the 8th semester, then last, my lord.
But that awarding of gold medal will be in convocation ceremony.
Convocation ceremony.
Convocation ceremony is yet to happen.
Yet to have, my lord, then 13th, my lord.
But how you assume that it will not be given?
So, because, my lord, they have made a representation.
Where is the question of representation?
So, but till date, they have not implemented it.
That is
Lordship. It's absolutely correct.
your right to remedy arises.
Yes.
Post convocation.
My lords.
It cannot be granted in advance to you.
My lords.
We do not know.
Lordship, that, my lord. Yes. But
therefore,
our presumption is, my lord.
Why do you presume like that?
Lordship, my lord, I have made an application, but they have not responded until date, my lord.
It is not an application.
Lordship.
It is an honorarium.
Yes, my lord.
It is by way of honor that is being done, not an application.
And one another thing, my lords. Apart from the CGP also, they have also published in the internet, my lord. They have got today, my lord. The list of gold medalists, second highest rank holder. I have also second rank holder. Either or, my lords. I will eligible, my lord. Lordship, kindly for lordship. I'm sorry, my lord, I could not file an affidavit in today, my lord.
Sorry, I will
Yes, I'm sorry. Lordship, kindly. Yes,
I'm not on that. How?
Lordship, yes,
it's
lordship.
a premature petition, brother.
Lordship, keep it pending, my lord. Yes, lordship, keep it pending, my lord. The 13th, lordship.
All this matter next week. Next week, all right.
Yes, lordship, 13th.
On 13th itself,
no, my lord.
Going on 13th.
After 13, my lord. After 13, I'm sorry.
On 15.
My lords.
At the request of counsel for the petition. Yes.
Grateful.
Just look into one decision of Karnataka High Court by Justice S. Mohan when he was Honorable the Chief Justice of Karnataka High Court. Anjay Bansal versus Bangalore University. I do not remember, maybe 91, 90, 92, 92, 93. Just look into that. Anybody Google out that decision? Anjay Bansal versus Bangalore University. Identical issue arose. in a different context. Just look into it. Can you find out that judgment? It's a state of Sanjay Bansal versus Bangalore University. Justice S. Mohan, Chief Justice, judgment. 92. It's a reported judgment. Sanjay Bansal versus Bangalore University. 10th November 1989 it is. ILR 1990 Karnataka 23, AR 1990 Karnataka 225. Just look into it and come back. It's in a different context, but it will have some reflections. It may help you. Yes. 15 September.
Item 24. Similar matter. The Lordship is directed to issue notice to all of this.
Number 10, 20. All this matter along with the WT number 24069 of 2025. All AG? Yeah.
Item 25.
This is a matter relating to the direction to dispose of the execution case which is pending 2015 minor before the.
Do you have Rahul Shah?
Yes, Rahul Shah, and your Lordship also passed the order basing upon their judgment.
No, Rahul Shah is based on my judgment.
Yes, they are basing upon their. Your Lordship also passed this order in division of engineering appeal.
No, not only that. Even Rahul Shah itself is my judgment.
Yes, ma'am.
Which it is.
In two forums they have failure, my lord. Appeal is dismissed as well as the review petition is also dismissed.
Execution is pending since how long?
2015.
2015.
Annex 2.
Let down. Petitioner is
petitioners.
The petitioners are knocking at the doors of writ court. The state is the party there in execution.
Yes, my lord.
Huh?
Yes.
Grieving against long pendency of the execution case number
71 of 2015.
71 of 2015. First up, counsel for the petitioner, banking upon Rahul S. Shah versus Jitendra Kumar Gandhi, 2021, 6 SCC 418, submits that every execution case has to be accomplished within an outer limit of 1 year. Whereas in the case of his clients, 1 decade has passed, not even a leaf having been turned. First, kindly sit down. He also draws attention of this court to a coordinate bench decision in Rajat Kumar Dash in writ appeal number 1788 of 2024 between Rajat Kumar Dash versus State of Odisha and another. This court of while order dated 2/7/2025. First, next paragraph. Learned AGA on request appearing for the respondents. Do you oppose? If you oppose, I will impose cost.
No, you are.
If you agree, I will not impose. Yes. AGA appearing for the OPs who happen to be the judgment debtors. Correct? Judgment debtors. Does not oppose the petition. First off, he contends that some reasonable period be fixed for the accomplishment of the execution process with the participation of all the stakeholders. First, with this proposal, counsel for the petitioner is, are you agreeable? Is fairly agreeable.
Only
First,
small. Well,
in the above circumstances, which court it is?
State Education.
State Education Tribunal.
State Execution Tribunal, that is OP number 4, is directed to hear and dispose of the subject execution case within an outer limit of 3 months.
Well,
3 months will be too early.
Yes.
6 months will see.
3 months, because your lordship's permission, I make a small prayer. They have, after the order of the Education Tribunal, they have gone to my lord, the High Court, my lord, in a FAO. FAO dismiss. Thereafter, against the FAO, they filed the review petition. Review petition also dismissed. I mean, 2023, my lord.
Within an outer limit of 4 months. And report compliance to the Registrar General of this court. Failing which, it is open to the petitioner to file appropriate application for taking appropriate action against the jurisdictional authority. First, all contentions are kept open. Okay. Why 10 years? Other day, 97 execution. Yesterday. 97 execution. LRs of the LRs should be brought on record. They will not know that their great grandfather had filed execution petition when Alexander had come to this country. Yeah.
It was 326 BC also. 26 BC possibly.
323.
Judge is always right.
The history says that way. BC 322. Yes. Yes, sir. What it is?
I am appearing in this case, Your Lordship. I am appearing in this case. My Lord, Your Lordship had earlier interfered with Annexure 1. This is regarding the fate of 2,000 vocational trainers. So who are they're working for since about 10 years now. Now, my Lord, they came up with a plea that they want to change the service providers. New agencies are to be created. In the process, we are likely to, because new person will come in. So in the process, my Lord, we will lose our job and we are already put in 10 years of service. We made
since last 10 years.
Yes, more or so, my Lord, 9-10 years. So, my Lord, we made a representation not being considered. We approached Your Lordship at page 67, Annexure 5. My Lords, relying on Dipti Pandey case, directed to look into the matter within 6 weeks on filing of on decision to be taken in the matter. There was a submission made by the learned AGA that before the ink could dry up, the petitioner has rushed to this court. That is in the paragraph 2. Anyway, that is something else, my Lord. Now, on the next day, we submitted Your Lordship's judgment and a representation in Annexure 6. This is the order passed and kindly look into it.
Annexure 6 page number?
Page 70, Your Lordship.
What they say?
What they say, they didn't say anything. Now here that ink could, before the ink could get dry, on 30th of August 2025, my Lord, they issued a program for recruitment of these vocational trainer through the agencies. And program is 31st August is the advertisement, 10th September is the interview.
When we come to last, the penultimate paragraph?
Yes, Your Lordship. All vocational trainers shall be fluent.
No, penultimate, the last but one paragraph. Taking into consideration above said facts and the judgment referred to above, existing VTs working in different education institutions may be allowed to continue in their respective schools, irrespective of the change of VTs. Yes, they all will be continued.
Hello?
You will be continued.
Your Lordship, that is my Lord's order.
No, it is there, this one, Secretary's order itself.
After your
that is 2025.
After your
1980, Your Lordship. 1980, my representation.
Huh?
My representation. My prayer.
Your prayer.
Yes, your lordship.
To that, what is the response?
Response is next page, Annexure 7.
You are right.
Your lordship's order is dated 18/8. We served the copy to the authorities concerned on 19/8. Now they come up with on 30th of August 2025, the program regarding recruitment of race candidates. Engage before they could dispose of my representation and consider my case. The program, your lordship may look at 10 September is the date of interview and document verification. Tomorrow.
Yes, brother. Where is the consideration of their case?
I'll take instruction. I have no.
But don't process this. Issue emergent notice.
There is a participant.
Learned EGA on request accepts notice for all respondents. Which respondent?
The AGAPS.
8 1 and 2. Others are private.
Yeah, all are yours.
Private.
Private.
Issue emergent notice to arrest. Returnable within 3 weeks. First stop. Next paragraph. IA is filed for interview.
Yes, your lordship. Stay operation of Annexure 7.
An application supported by an affidavit is moved in IA number?
IA number, my lord. Sorry.
14959.
14910.
910.
14910.
14910 of 2025. Seeking reprieve against the impugned order dated
30th August.
30th August 2025 at Annexure 7. The first. Learned senior advocate appearing for the petitioners draws attention of the court to the earlier order of this court in WP number
22418.
P number 22418 of 2025 disposed of on 18/8/2025, wherein consideration of petitioner's representation in the light of WP 18481 of 2024 between Deepti Pandey versus Union of India disposed of on 22/8/2024. Person. A prima facie case is made out for granting provisional protection. Since the very breadwinning of the petitioners is at stake. First, next paragraph. In the above circumstance, the application having been favored, the impugned order dated 30/8/2025 at Annexure 7 is stayed, coupled with a direction to continue the petitioners in the job till next date of hearing, with same terms and conditions as we are obtaining hitherto.
May I pray for a copy of the resolution?
It will be prepared that and we're posted before lunch. All right.
Not before lunch, your lordship, in course of the day is good enough. Obligement.
Item 27. 27.
27, the petitioner has challenged the transfer order under Annexure 2, my lord. The petitioner is a lady primary school teacher, and my lord, as per Annexure 3, the government, as per the notification of the government, the MLA has recommended the transfer, my lord. Similar order has already passed, my lord.
Any representation you have made?
No, my lord. That is MLA MP sponsor.
Same order, and we'll group all these cases and decide by one stroke of this side or that side. In the meanwhile, bring Karnataka judgment. You got that judgment?
Yes, yes. I'm having.
Just look into that judge, Justice, Honorable Justice Pandit and another judge of Karnataka High Court have looked into that aspect of the matter. Okay, that is, yeah. All right, issue emergent notice. I have given the copy. Learned AGA accepts notice for the OPs. First up, Learned Counsel for the petitioner has moved an application seeking interim protection. Since his client is likely to be dislodged from the place in which he has been working, he or she has been working. First up, he tells the court that in identical matters, this court has already granted reprieve to the similarly circumstanced employees, and therefore the same cannot be denied to his client on the principle of merit. First, there is force in this, prima facie force in this submission. Next part, in view of the above, the impugned transfer order, so far as petitioner is concerned, is stayed, coupled with the direction to continue the petitioner at the same place wherein she had been working before its issuance. Till next date of hearing. Call this matter along with WP number 12344. No. WP number yes.
Item 28.
Can I come back within a couple of seconds? Yes. Yes.
Item 28.
I put the advertisement in the year 2004. The petitioner applied for G category of plot in sector 30 and deposited the initial amount and rupees 15,547. That amount.
We'll take up old matters first. Then we'll come to your matter. Your matter is of 2025. 2016 matters are pending.
My lord, tomorrow the CDA is going to make a lottery system.
Tomorrow?
Tomorrow.
Tomorrow lottery will be there. But
how is your throat today? Not well.
Bit not well.
I have filed a IA for this.
Let's first step back to my because of this. Tomorrow lottery will be there. That will be there. There is no problem. But fact means, my lords, he has not applied in due format. Only deposited that amount. If format described, affidavit to be given.
I will explain what has been done.
Now, may submit minors. All that lottery may go on. If you succeed, then we'll see that latter part minors.
I have filed the IA to reserve a plot for me.
No.
Because I had filed, deposited the amount in the year 2004.
You conduct the lottery, but don't give effect to the result.
That also.
Because he has already deposited that money long ago.
No, minors.
No, he has produced that material.
Yes. That amount has been refunded. Refunded long since. Thereafter, they participated. They required to participate in an auction process. Then come before the Hon'Ble High Court. Hon'Ble High Court said that go and participate in the auction process. There also he didn't participate, didn't apply, and filed a contempt that as if we have not allotted. Then minors, this is a new set of plots minors. It is put into auction. There also he could have applied for.
When application should have been made?
But after 2025.
No, what was the last date?
Last date was minors. That last date of application was 20.
Which was the last date for application? You tell them.
Give me man.
Your petition. When did you apply?
I applied in the time.
Show that. When did you apply? What was the last date? When did you apply? What is the color of your application? I want to see.
Last date for applying minors, it is 9/3/2025.
9/3/25. Yes, sir. Where is your application, sir?
Will you look at my lord's annexure 16, page 129. It's a plain application, my lord.
Yes, filed it before on 9/3/25.
That's correct, my lords. He filed it, my lords, in a plain application. We
Where is the prescription?
my lords, annexure 14.
42.
41, my lords, page 106.
You have retained that money.
Which man, lords?
The money earlier which you had paid in 2021. Wait, go to the same page.
My lord, in the year
Earlier he had deposited, you retained that money for 5 years and one fine day you returned without interest.
That was returned way back in the 2012.
Very well, I understand that. Thereafter, on 17/10/2021, he deposited 1,182.
Yes.
That is in connection with the auction.
Auction.
That was also not in due format. And that was also, he didn't participate there.
Did you return that money?
Yes, madam.
no, that amount has not been
That is what
returned.
he is saying now.
I'm telling, with the due humility, my lords, I'm telling that 1,100, what he is doing, my lords, he is depositing in challan in the account without giving a number. That is what we have taken in counter also. Here also, he has done the same thing. We have prescribed a format, we have prescribed a procedure, we wanted an affidavit which should be accompanied with all these things, that you have to file it, you have to deposit the amount. Instead, he has gone and deposited in challan and kind of glance to page 128.
My lord, there is similar order.
Even if, my lords, I send it, my lords, to draft, he is not receiving. And that amount that is in the challan, so there is no account number so that we get big.
All right, all.
In the order,
No,
What
my
do
lords,
you want?
no, first, what's the question?
Do you have water?
No, so that's all right, my lord, take care, no problem. This will
So you
continue.
conduct auction tomorrow,
Yes.
but don't finalize it.
Okay, my lord, that's all. The auction tomorrow and day after tomorrow, my lord,
Let
the
it
auction
go
will
on.
continue.
my lord, I have filed the IO to reserve a plot for me.
Is it a question of lottery?
We will not give effect to that lottery.
Because there is, yes.
Heard, learned counsel appearing for the petitioner and learned senior panel counsel appearing for the OPs. First up. Learned counsel for the petitioner draws attention of the court to his application dated 9/3/2025 at Annexure 16, which mentions about he is depositing a sum of rupees, nearly a sum of rupees 1 lakh, way back in the year. No, you had deposited only 15,500.
In the 2004.
15,500 way back in the year 2004. And the same has been refunded.
15,000 only refunded and 500 is with them.
Huh?
15,000 has been refunded.
500.
500 is with them.
It also mentions about he having deposited rupees 97,550 plus rupees 1,180 in terms of the advertisement brochure number 1 of 2025, comma, by RTGS. First one. A prima facie, first one. Learned senior advocate appearing for the OPs opposes the grant of any interim order, saying that the auction is already scheduled and it should be permitted to go on, culminating into grant of sites to the successful bidders. First, he also tells that the petitioner has not made any application in the prescribed form and that merely depositing some amount will not satisfy requirement of first. Next, having heard counsel for the parties and having drafted petition papers, some reprieve needs to be granted to the petitioner, and therefore, although the scheduled auction shall go on,
My lord, that is lottery.
comma, the scheduled lottery shall go on, comma, the same shall not be given effect to till next date of hearing.
For selection of the candidates will be there. Selection of the allotment.
It is open to the OPs to prepare the selection of allottees.
Pursuant to lottery held.
Unhindered in a normative way.
My lord, there is similar order passed by Honorable Justice A.C. Behera.
On this matter on 23/9. All right.
Item 29.
Item 29, my lord. Pursuant to my lord's direction, my lord, I have last order. Already received the documents, my lord. I want 2 days time to file it, throw in affidavit, my lord. Taken on the day after
16, madam.
My lord,
They are also directed to produce that selection list.
Select list prepared pursuant to the recruitment process undertaken in terms of the notification dated 25/3/2003. Do you have that copy?
Yes, my lord.
Give that copy. You want to file objections?
No, just no, I thought I want to
of an affidavit. Today morning they came from both. So available is there.
We'll call this matter day after.
They are it will be thrown.
If the requests. Next. Sir, you can go home. Which is the other matter? Don't worry about it. Just mention it.
I've taken counsel.
Go. Yes.
A copy of that may be provided to me.
Yes, give copy. After that, no, they will give the entire affidavit.
Affidavit with affidavit along with the copy.
Yes, yes, my lord.
Next.
Item 30.
Challenging the cancellation of allotment of a residential flat.
You should make use of the mic. Larger the voice, stronger the voice, larger the justice.
It was
People will start shouting, my lord.
Therefore, I said voice.
what happened? The LIC constructed 420 houses.
Before my learned friend says, should I assist your lordship in a way so that it will concern the issue?
Yes.
There are Lord 5 writ petitions. Lordship will find there is interim order in one matter. Out of 5, 115/804 of 2019, your lordship may kindly take up first. That's the case why I am saying to take up 15804 of 2019. Why I say it is to be taken up first. Here is
it's your choice. It's in the group. You need not reason out at all.
This is
here this matter.
This is a little different, and it is on this ground that this petitioner, prior to approaching this Honorable Court, had approached the Consumer Forum challenging the cancellation of allotment. Consumer Forum passed an order upholding cancellation and directed refund of the money with interest, 9% interest. That we have also complied with. In the meantime, he has approached the National Consumer Forum, and that is pending there in the appeal. He has not disclosed this fact in the writ petition and approached directly. So 77.
Who is the petitioner?
77 Supreme Court said that it's a parallel proceeding, not
This is not my case.
Your lordship, I am appearing for the
Who appears for the petition?
Your lordship, I am appearing for the petition. Kindly allow me to appear through VC. Your
No, not only parallel proceedings. Already there is an order.
Yes.
And now in appeal.
Yes.
How can he argue this matter here?
Your lordship, I am appearing through VC. Your lordship.
All right. How can you maintain writ petition when your appeal is pending before the National Consumer Court?
I was not aware. I will take instruction. Just one opportunity may be given, your lordship.
No, not that thing.
He has suppressed it.
2016 matter.
Your lordship, I was not aware. Your lordship, only 1 week may be granted. Next week, I will take instruction, your lordship, with regards to the matter before National Consumer.
If order is wrong, you may move memo. I will restore the writ petition. All right.
Only one opportunity may be given, your lordship. I will take proper instruction, your lordship.
The petition that the rate of. In WP number, right now.
All I pray is only 1 week may be granted. I'll take proper instruction, Your Lordship, and I'll present the facts as it is before Your Lordship.
Petitioner has structured his prayer as under. First, learned senior advocate appearing for the answering OP resist the petition contending that kindly be seated wherever seats are there. Look into and then sit. Resist the petition contending that petitioner had approached the State Consumer Forum. District Consumer
Commission.
District
Consumer Commission.
District Consumer Commission.
State Consumer Commission.
Both are commission only.
State Consumer Commission.
State Consumer Commission.
Then NCTS. Then the National Consumer Commission.
Give the particulars of those this one consumer complaint number.
Madam, the 61. That is 61 of 2014.
Complaint case. District.
Please can you pass it on to me?
The State Consumer Disputes Redressal Commission 61 of 14.
Therefore, not district.
Not district has to be a forum.
State
Forum.
State Consumer Dispute Redressal Forum. While complaint number
61 of 2014.
61 of 2014, which came to be disposed of by the order dated
4/1/2013.
4/1/2023. 4/1/23.
Right, madam.
4/1/2023. Directing refund of ₹1 lakh with interest at the rate of 9% per annum from the date of deposit, along with ₹50,000 as compensation to the petitioner. He further tells that the petitioner has taken the matter in appeal in first appeal number 392 of 2023. Yes. That is now pending on the file of National Consumer Disputes Redressal Commission, New Delhi. And all these facts have been suppressed in the petition. First, even otherwise, the council submits, pursuit of plural remedies is not permissible, and therefore the petition is liable to be dismissed. First, next paragraph. Learned counsel appearing for the petitioner repeatedly sought for adjournment, short adjournment, to come out with the instructions from his clients. First, the question of adjournment would not arise in a matter which is pending since
2006. 19. Petition is 2019. 19, sorry.
2019. The facts submitted by the learned senior advocate, Mr. Ratnuraj, appearing for the OPs are a matter of record. Copies thereof are made available to this court. First off, next paragraph. In the above circumstances, this writ petition is dismissed. With liberty to petitioner to seek its revival in the event the facts asserted from the side of OPs are found to be untrue or false. So it's obvious for
there is one more preliminary submission for the other matters. Other matters, I have a preliminary submission. Rest of the matters, the allottees, separate batch of allottees, they had approached this honorable court earlier. Other allottees, they wanted allotment and challenged the auction. Now there is a judgment passed by the coordinate bench of this Hon'Ble Court dismissing the writ petition. Question of their allotment, giving them possession and auction by us. Now the matter is pending in writ appeal. One of those persons have approached the writ appeal court, subject to my lord, whatever your lordship.
Their cause of action must be different than.
Can you see the judgment? Can you see this?
Same
group of allottees or
same cause of action.
Same cause of action, exactly.
Lord, there the prayer was to set aside the auction, respect the allotment, deliver back possession.
I am clarifying.
Here, they are challenging the cancellation of allotment.
Very same auction.
Beg pardon?
Allotment made pursuant to very same auction.
Same auction, not auction, lottery. In fact, lottery.
You have no auction procedure here.
Procedure, thereafter we have adopted auction procedure. That is what was challenged there, along with to reinforce the earlier allotment through lottery. Now, which they are seeking also here.
What
So that
happened,
is
my
pending in writ appeal.
So one by one we shall take.
Right.
Start the first one. Yes.
What happened? The LIC,
Your other friends need not wait. They can go for lunch bit early. Did not. This will take some time. Yes. Start.
so the LIC constructed 420 houses. Out of that, 345 were already been sold.
One second. These are flats were constructed.
Apartments. Out of 420.
420. Which 420? Section 420?
No, out of 420 apartments, 340 have been registered.
420 flats. Of them, 320 are already allotted.
345 have already been allotted. Already been registered, my lord. Not allotted. It has already been registered. First allotment through lottery, then registration.
So the allotment only.
When our term came, suddenly a notification came from the side of government that unless ROR is in our favor.
No, the sale deeds are also registered.
That is sublease registered. Leases. Already registered.
They are lease cum sales. Or only leases.
Sublease. They are saying sublease.
My learned friend is probably confusing. Kindly see page 13 of the writ petition. Page 13. Yes. It is advertised by LIC for the purpose of distribution of flats by way of lottery.
Page 13.
I am holding a sample writ petition 6240 where I have prepared my list of dates. All the matters are same. Kindly take up 6240 of 2015. All the matters are same. So facts are not different. I think. This is the advertisement.
I have also
So admitted question. Kindly turn to page 13 of 6240 of 2015.
6240
of 2015. And I have prepared a small list of dates for my lord's.
Kindly give that. That helps me. Share a copy with your friends.
I'll share it. You want to copy it?
Yes.
Lordship will find that in the year 1992, GA department allotted a patch of land in favor of LIC for the purpose of group housing and construction of houses.
Yeah.
Now, 2014, Lord, if Lordship see that's part of record, the state government executed lease deed in favor of the LIC. There, your Lordship will find page 23 of our counter. It was never disclosed that it's a forest land. It was never disclosed by the state that the land allotted in favor of LIC is a forest land. Neither they disclosed it in the lease deed nor anywhere there before. Now, after allotment of this land, LIC issued advertisement for the purpose of allotment of the plots. That your Lordship will find page 13 of the writ petition. Total advertisement was for 75 houses, not for 20 or something like that. The advertisement clearly said 75 numbers of ready-built plots under LIC policy sold.
For 75.
75.
But that you have not stated in the list of dates, no?
But 75 number is not given, but advertisement is there. 75.
Out of?
The total 75.
No, total 420 in phase 1. This is phase 2. 75.
But the advertisement doesn't speak of phase 1, phase 2.
I have annexed one document. Your Lordship may kindly go through.
Decide that.
So I am not saying out of.
Let us not join issues on this aspect. Lordship will decide that. But our advertisement is confined to 75. Now, lottery was drawn 26/3/2014. Allotment letters were issued. Allotment letters were issued on 7/4/2014. Allotment letters were issued. Now, after allotment letters were issued, 24/4/2014, registration stopped for want of ROR by of amendment. Registration Act went on underwent an amendment. 22A was introduced, wherein it was made that ROR is to be made compulsory for the purpose of registration of any title.
ROR is record of rights.
Record of right. Now, this lease was not backed by record of right, nor it was ROR was corrected in the name of the LIC of India. So it got affected by 22A. Now, what we did thereafter, LIC applied for mutation. 29/5/2014, we applied for mutation. Now, 6/6/2014, letter issued by IGR for facilitating registration of sublease K/1 and H1, we issued these letters to the IGR, Inspector General of Registration. Now, 25/8/2014,
they informed you.
But this is our request for the purpose of registration to enforce these allotments. We pursued it.
In whatever land is allotted given to you on this basis.
Yes, my lord.
You wanted an entry in ROR.
Right, madam.
So that after you build construction,
we can reallot them and register it also. It is in their interest, we pursued it. Now, 25/8/2014, the government for the first time intimated LIC about the fact that land allotted is a forest land and diversion proposal is necessary. As your lordship knows, Forest Conservation Act 1980 prohibits all kind of development over a forest land. Completely prohibited.
That you did not know.
We did not know it.
Because state gave the land to you.
State gave the land to us and did not indicate that it's a forest land. Now, after
what
this,
is the extent of land it is?
Well, it is 10 acres.
10 acres.
Yes.
Then who appears for the state?
My friend will appear for the state.
That is, my lord, no more an issue. Now ROR is in that.
It should know.
Now I am just
issued. They are selling it through auction. Whether the lottery holders will suffer or not.
Question is, out of this
that barrier is over now.
1 second.
Out of the 75 allotments, after all these things from 2014,
now ROR is given.
23, we pursued the matter, and as a 2023 notification, it becomes a non-forest land. For the purpose, my lord, now your lordship will appreciate. LIC is a government of India undertaking. Now we are as good as a state. Now,
or a state.
Yes.
That's what 86 Supreme Court says.
Right, we are a state. Now, these allotments which were made through lottery as back as 2014, LIC took a policy decision that now things have changed, costs have increased, distance of establishments have been increased. So we will not abide by the lottery procedure now, we will put it by auction.
But you adopted lottery procedure.
Initially it was lottery.
And you gave allotments.
Right, my lord, allotment letters.
How can you rescind?
Right. We cancelled those allotments by virtue of a policy decision saying that we will resort to auction procedure in the interest of the LIC and also the revenue.
What is the gap? When the decision was taken to for lottery, lottery decision.
Lottery was 2015.
No, lottery was held.
2014.
Lottery was held. When you took
26/3/2014. Lottery was held.
My lord is asking.
When you took
a decision for lottery. That in fact I'll have to get and produce it before that. I'll produce.
When you took that decision must be
on the policy decision of the board. Obviously, someone cannot take it. There has to be a decision.
Task for
I'll produce
just
it.
give the date. I'm not adjourning the matter.
But no,
no adjournment.
I'm not asking for adjournment. I'll get that instruction. I tell you.
Send somebody to ask.
He will get when it was taken. That will be intimated to him.
And when you changed that decision.
Yes, my lord. Those two decisions, lottery and auction, those two dates. In fact, yesterday night I could not get the instruction from. I'll try to get it.
You can come from here only.
But I'm trying to get it from the concerned officer. But even if that getting it
once. See that you are stopped from doing it. Prima facie. For reasons I tell you. Because that lottery procedure is held out to the public at large.
Yes.
And the petitioners participated. They have given money also to
yes.
You deferred registration on the ground that ROC was not given to you.
ROR and the forest land issue.
It was a forest.
So it was
that has gone now.
23.
Well, it has gone in 25.
Right.
We'll assume that way.
Right.
2 years grace period. How can you take advantage of that?
Right.
What is their fault?
But I'll now explain it, my lord. I'll not just explain it. Your lordship will. Now, it was a decision lottery in 2024. Right, my lord? Now, out of these 75 allotments, 70 persons.
2014.
1 second, wait. We'll come to you also. He's arguing one particular matter. Do not disturb. It gets distracted. Yes, we may not agree, but we should respect when advocates are on their feet. Yes.
But 2014 was the lottery. Now, when it was detected that Forest Conservation Act come into play, obviously I cannot be forced to do an impossible act because it was impossible by operation of statute.
Correct.
So see that judgment, my lord.
Correct. Why a judgment? They are taught to be in first year law by my professor.
So jurisprudence.
Yes.
So we cannot be compelled to perform an impossible act.
Correct. But impossibility has now gone.
Once it is gone,
yeah.
Now the LIC of India took a policy decision.
On what basis?
Basis that lottery and auction. Auction is a transparent method. 1, 2. In view of the huge time gap, the cost and other things have increased manifold.
What is your contribution to that?
No, it's not our contribution. Our investment is there.
But they have invested. No, they have given the money to you.
They have only deposited the money for the purpose of allotment.
Correct.
But final sale deed has not been executed. Final lease deed has not been executed. I'm just telling, my lord. I'm left halfway. I'm just telling, out of 75 flats, my lord, 70 flats have already been put to auction. And those purchasers, they have taken over possession and they are enjoying those flats. Only these 5 flats, those who are pending in litigation before this honorable court, today all these flats we have not put to auction, 70%. And today if I'm directed to allot the land on the basis of lottery, but those persons whose plots have been auctioned, kindly appreciate that, my lord.
No, we tell them. In this, there are nobody here.
That is one more thing, my lord. Kindly consider. My lord, another batch of matter, same allotist whose plots were auctioned, they had approached this honorable court and matter is pending in writ appeal. Whether it will lead to an inconsistent appeal.
No, this also you will take in writ appeal.
No, we are not taking. This honorable court dismissed it, referring to Ballery Industries case. Kindly see, man. There, writ petition was dismissed. The lottery allotment through lottery was cancellation was upheld. I have given that order, Lord Kindly see. Data no hema. Justice Panigra judgment.
What that cancellation was a lottery specific? Lottery specific?
Upheld.
No, you're not.
I'm not
listening to my question.
I'm not getting.
Whether that judgment is lottery specific or policy decision
specific. No, cancellation of allotment is upheld by LIC.
On what ground?
On referring to Ballery Industries. Justice Panigra judgment of the owner. Lord, I have given that judgment. It is here, Lord. I'm so sorry.
But before it was acted upon. In that case,
they identically placed.
They had deposited the money.
They have deposited the money. And they were asked to take back. Here also they have been asked to take back. Similarly placed. Kindly see the judgment, man. Kindly see.
You.
I have given that.
Do you have copy of that?
Yes, I have given to your lordship, Lord. Lord, WPC 9180. Kindly see, Lord. Para 1 itself. Same, Lord. Identically placed. Since all the writ petitions involved. But you get that, Lord?
This coordinate with judgment.
Yes, coordinate with judgment. 9180 of 2025. Since all the writ petitions involve a common question of law and substantial similar fact, they are being taken up considered. Now, para 2, petitioner in WPC so-and-so challenges cancellation letters. That has taken place here also. Of 2014, same. And e-auction notice dated so-and-so, he also seeks passing of these notices and a direction LIC to register and hand over possession of previously allotted flat upon payment of the remaining consideration. The same issue here except auction. Auction is not challenged here, but cancellation of allotment here was the challenge, there also was the challenge. Kindly see para 6 onwards.
What are we doing?
Yes.
So what I'm trying to impress
No
upon-
appeal is filed against that. That matter is in
appeal is pending. Appeal is pending. So that's what I'm trying to impress upon. Lord, let's wait till the appeal attains a finality. Instead of doing the matter on merits, now it will lead to a conflicting of decisions.
Let us ask them what they will.
Lordship may see paragraph 5 clause 3. Just now I received the copy.
Paragraph 5.
5. Says the cancellation letter dated 19/12/2014 was never challenged at the appropriate time. So those people have never challenged the cancellation, suddenly came challenging the auction. That means they considered to the cancellation.
But that is not made a ground in the reasoning.
Yes.
So it was argued. That is not made a part of the reasoning.
So they are loco standi against auction, considering the cancellation. Here we are challenging the cancellation and our houses are reserved.
What is the amount you have deposited?
1 lakh token amount, lottery, and 345 people have already taken houses. I am showing one annexure. One annexure in my case, WPC.
No, Mr. Rath, in that matter, the cost was not paid. Only token advance was given. Paltry sum of token advance.
Same, my lord, as in these cases. Same, everywhere same.
No.
Because LIC cannot accept different money, different price.
No, that is not the case. Went upon a reasoning that the only token advance was given.
Here also the same thing.
Which is that token advance?
They denied. They deferred.
1 lakh,
How much money you have to give?
1 lakh.
62 lakhs, they deferred. Lordship may see annexure 4.
1 lakh, here also 1 lakh.
In first case, the Lordship may see annexure 4 are at page 36. I am reading out. We have therefore applied for record of rights to Tahsildar Bhubaneswar on 29/5/2014. It is understood that to get the record of rights, it takes considerable time. Therefore, we have decided not to receive any payment from allottees till we obtain the record of right. And last date of receiving the payable amount shall be extended. The last date of receiving of payment shall be intimated to you after receiving the record of rights. Thereafter, they also said anybody interested to take back his amount, they can take back their amount.
All of them are.
And I preferred not to take back in my amount. I was interested in house. That was also my letter. So all of a sudden, unilaterally they cancelled. Now your lordship may see annexure, another page. They are saying only 75. No. Page 58. LIC of, it is a letter from LIC to Additional Chief Secretary to Government, the second para. The LIC of India has constructed 420 number of flats on the said plot number 8 at Chandrasekharpur, Bhubaneswar under policyholders housing scheme in 2 phases. In the year 2000, 192 numbers flats were constructed in phase 1. Recently, phase 2, 228 and such. Lastly, however, 75 numbers balance flats have not been offered to policyholders by advertising on 22/12/2013. So 420 numbers of houses on record and 345 are already taken by virtue of lottery. These 75, the registration was delayed only because of that notification. And once it is regularized, now there is no barrier that jungle land or something. Now they could have.
You deposited 1 lakh rupees when? Which year?
In 2014. And our houses are in the meantime depreciated.
Your houses are?
The flats are remaining vacant since 2014. There must be some depreciation. That is another thing. Now they are saying the cost of the apartments are growing.
What is that government of Odisha letter dated 22 to 2014?
That is with regard to clarification, kindly see, counter there. That is their part of our
Mr. Arath, the only ground why you did not give registration, the conveyances, was because it was a forest land.
Forest land.
No other ground.
Forest land, and it was not backed by ROR in our paper.
That's fine.
Right.
Because it was a forest land, ROR was not.
ROR was not there.
Subsequently, ROR is given.
Subsequently,
how can you take the mistake of some others to the disadvantage of the?
I am not now asking the disadvantage. We have taken a policy decision that these 75 flats which were constructed, not registered at the relevant point of time, we will put it to auction, which is in the interest of the public sector undertaking. Now 70 flats have been sold out. People have taken up. And out of these seven persons, one of them is retable, it's pending with regard to validity of our cancellation. We cancelled their allotment. We said that you take back your 1 lakh rupees. Kindly consider 1 lakh.
Take back your 1 lakh rupees.
Yes.
Any interest?
With interest. Yes, with interest.
What interest?
No, we have requested them.
May I submit my list? Let him complete.
Kindly see that letter, my lord.
What is that interest rate you have given?
Yes, page 41, my lord, of our counter. Of the rate, my lord. I'm sorry. Of the rate. I'm so sorry.
I am asking the rate of interest.
My lord, I'm just telling you.
Page 41.
Lord, we have written them as the flat allotted to you as stated above stands cancelled. Application fee, it's only application fee.
We're asking you what is one
application fee 1 lakh deposited by you shall be refunded to you by NEFT to your bank account. You are therefore requested to provide us the bank account details enclosed format along with cancellation check for facilitating refund process, or else LIC free from any obligation for future. Blood interest is not written here.
And then?
Not written here.
You want to make profit now and you don't want to give interest to them.
Lord, I will pay interest.
Now you are saying so many things.
Lord, consumer has passed order to pay interest.
That I don't do. That does not bind this court.
Lord, that I am not asking binding your lordship. Lord, what I am asking is
the confidence. You are a statutory body.
Yes.
You postponed allotment on the ground that there was some technical problem.
Yes.
Which has been solved.
Right.
You did not postpone it because you wanted to make benefit or go for commerce.
Not at all.
They are in a particular housing scheme.
Yes.
You have done all this. You held out to the public at large that we are constructing so many things and all you can apply. We will allot them on a particular condition. You had given the allotment letter. They gave 1 lakh rupees way back in 2014 when money value was.
But money is only 1 lakh application fee. No further amount.
You may call it application fee.
No,
they may call it allotment fee.
No, it's not allotment fee. Admitted position is an application fee. Vested right in their favor. Mere issuance of an allotment order without any further agreement or transaction or deposit doesn't create a vested right in their favor. It's an application fee only. It's only an application fee. Beyond that, no deposit.
No, application for what purpose?
For the purpose of participating in the lottery.
That is for allotment only.
But the consequent thereupon also an allotment letter has been issued from our side. Yes.
Allotment letter is issued.
That's not final. That doesn't create a vested right in their favor.
Where have you stated the allotment letter is liable to be cancelled?
But that's kindly see.
So that
allotment letter we have not said. We have not given in writing that. But allotment law with regard to allotment is it doesn't create a vested right. I can cite judgments also.
No,
I can cite. Lordship, see, it's a public largesse, public property. Natural resources case and some other judgments I have with me. Lordship, kindly see that judgment.
Correct. But having take out.
It's a lottery procedure. Earlier,
you rightly or wrongly in 2014 you took that decision.
Right, Lord.
And to some of them, you gave the lands also, houses also.
No. Question. My lord is asking.
Have you given any flats on the basis of lottery?
Yes.
They are given.
That I'll have to, two things.
On the first page.
Two things, that can't be said right now. I'll have to file.
He's saying it is given.
But he is saying that's not final because that is not whether those allotments are in respect of a forest land or not. Whether that was unencumbered property or not.
No, the question is,
if it was a clear land, it was a clear
had it not been a forest land,
right,
you would have already granted.
Obviously, but today the situation has changed, man.
How can that will inure to your benefit? Not to their detriment.
Not my benefit, my lord. It's a benefit to the state-owned organization.
That's what. Your means you are holding the
right
for him.
Right. It's not
for I say your benefit. I will say your benefit.
Policy, my lord. It's a question of a policy. We have taken a policy decision. Now, estoppel will not apply against a policy, but I'm citing the judgments for your lordship's consideration.
That is start to us right long ago.
Right, kindly take up the judgments, my lord.
Why judgment? I am in full agreement with the proposition.
No.
I am in full agreement. Even when I agree with the proposition, still you want to cite the...
No, I'm not. That's the proposition.
These are all the first year, second year law classes. Yes.
Right. But question is, Lord, today we have gone back from this
which law?
Yes.
Which law? Estoppel does not operate against law.
Lord, today, Lord, yes.
Which is the law?
Lord, I'm saying,
under which you are agreeing?
Lord, that I am saying, Lord, estoppel is a question of fact.
Correct.
And question of estoppel only on our representation if they have changed their position.
Yes.
Lord, they have not said
they have changed 1 lakh rupees.
No, 1 lakh deposit is no changing. Lord, change their position means
base is for
there is nothing, no pleading.
There is only for 115 estoppel. For promissory estoppel is not part of estoppel.
Lord, that is the law. That your lordship is to interpret and
no, Apex Court said that.
Finding here.
Apex Court said that.
Lord, today, bereft of depositing 1 lakh application fee, there is no other material available.
What other alteration they should have suffered?
The cost of the building, agreement to execute.
No, that's not the idea.
But that is what the judgment is.
The idea of alteration arises only under section 115 of the Evidence Act.
Correct.
But where it is a promissory estoppel, Apex Court said the law of promissory estoppel is the law of estoppel.
I'm citing Mallory judgment.
Yes.
Which says
it is already considered
which says that it is up to the authority. Mere issuance of allotment order is not final, doesn't confer a vested right, my lord. It is up to the authority to cancel the allotment. It is up to the authority to enhance the price. It is in our discretion, my lord. Now
your contention.
Yes.
Paragraph 5 of
I am citing that Valerie also before, my lords.
Yes, I have seen that. I have that judgment here. The next single judge has considered that. Anyway, you copy of that.
2 of 2018 balance.
Which paragraph?
Para 21, 22.
To the effect?
Trying to see. This finding in our view is not correct in the light of the facts and circumstances of this case. In case of Ramanna Sons has been distinguished here. There was no concluded contract in this case. Even conceding that BDA had trappings of a state and would be comprehended in other authority for the purpose of Article 12 of the Constitution, while determining price of houses, plots constructed by it and the rate of monthly installments to be paid, the authority or its agent after entering into field of ordinary contract are purely in its executive capacity. Thereafter, the relations are no longer governed by the constitutional provisions, but by legality, valid contract, which determines the rights and obligations of the parties interested. In this sphere, they can only claim rights conferred upon them by the contract in absence of any statutory obligation on the part of the authority, so in case of contractual paid. 22. There is a line of distance where contract entered into between the state and persons aggrieved is non-statutory, purely contractual, and rights are governed only by terms of the contract, no writ 226 of the Constitution of India, so as to compel the authorities to remedy a breach of contract, pure and simple, so and so. In view of the aforesaid authoritative judicial pronouncement of this court, in this series of cases dealing with scope of interference of a High Court dealing exercise 226 of the Constitution of India, in case of non-statutory concluded contracts, like one in hand, we are considered to hold that High Court in the present case has gone wrong in finding that there is arbitrariness or unreasonableness on the part of the appellant herein in increasing the cost of the houses, flats, rate of monthly installments, and giving directions in the writ petition as prayed for.
BDA had retained, kindly come to page 19, para 19. Para 19 of the judgment.
Increase the pet, right?
It had reserved.
Increased. It was a case of increasing the prices. Ours is a case of holding an auction on the basis of a policy decision.
No, it has retained that power, that right. Where is your right retention?
But it is always inherent. It is always, it goes by it, my lord.
No.
Allotment, my lord, my humble submission is allotment doesn't create a vested right.
You have said that. No.
Right, my lord, I have said
First
that.
one.
I have said that. But only thing is, if a lordship will again at the cost of repetition, if a lordship permits me.
May not be repeated. May not repeat.
Now the matter is pending in writ appeal where the cancellation, allotment cancellation is sub judice there. So to avoid conflicting your decisions, my humble request is to let us wait till the appeal is decided.
No. What are your submissions?
Para 5 of my writ petition, that is. That's 6240.
Yes.
Here, the LIC of India has already completed first phase of the scheme in the same location and also handed over 192 completed flats to different consumers under the policyholder housing scheme.
Have they, on the basis of allotment lottery, have they registered the sale deeds?
Yes, they are already. Yes.
Where have you stated that?
That in the same parameter. They are already. That 192 completed flats of different consumers under policyholder housing scheme and since year 2000. The already were occupied the same in the phase 2 scheme.
Which is this petition? You got hard copy.
And sub item. Sub item that finally location.
Why the function?
What is possible?
They have given the conveyances in these matters. Have you given the registered lease deeds in these cases? You have not given. You have to make a statement. If it is false, so that I can prosecute the false statement. Have you given registered conveyances in favor of persons mentioned in para 7?
It is their letter which is showing. In my case, it is their letter which is showing sublease has been granted.
Lease has been granted?
No, granted.
Where is that?
Page 60.
The
case number is.
No, what is your stand? You are for LIC?
No,
you are for whom?
LIC, I am
for the petitioner.
You are also for the petitioner.
I am for the LIC.
You are for the LIC. Whether I am asking a specific question to you, whether any leases have been executed in favor of the allottees under the very same allotment.
Would your lordship take it about 2 o'clock?
No,
come back.
answer is there, my lord. Their letter is there.
I will come back with that specific.
Their letter
2 o'clock you will come back. Which the letter you want to show?
Page 60 of the first item.
60.
60.
In the first WP. All right.
This 18, after due approval by Vocational Development Authority, LIC has developed the plot, constructed for 20 flats out of 345 flats have been allotted to policyholders and subleases have been executed. In favor of their letter.
That is a letter in first petition. Give that to first petition.
First petition.
Third person.
10,837.
Page number
60.
16.
My lord, 60.
60.
And in my case, no counter has been filed. It is para second, my lord, after due approval.
Do you have a LIC of India Act with you?
Right now, I don't have.
You don't have. Send the LIC Act. Third result.
Lord, can I reply to that?
Yes.
I take instruction. Lord, those allotments are by virtue of different advertisements, not on this advertisement. They are governed under different advertisements. So they are trying to club different advertisement, different schemes together and trying to draw parity.
Noted. I will treat that.
And other parties with regard to that registration and others, I'll take instruction immediately.
No, you have said that you are registering. 2 o'clock, you will tell you. Result.
My lord, I am handing over the.
That was reserved for judgment.
Judgment
I want to
tomorrow.
mention, Your Lordship, the last sub-item, Your Lordship, indeed, it was not actually concealed, Your Lordship. May I kindly draw your attention to the prayer where we have clearly mentioned that those cases are still pending before the Consumer Commission, Your Lordship.
Therefore, we have dismissed your petition. We did not say that you have suppressed.
Your Lordship.
Your Lordship, pardon.
Judgment tomorrow.
Pardon to make a mention. Your Lordship.
This is the instruction letter on behalf of Mr. Rattam Miller.
Send it to chairman. Okay.
Item 11. My lord. My lord, the petitioner is the widow of a Hindi teacher.
One small request. The judgments for my satisfaction.
Yes.
Which I came with those judgments we cited before my notes. I'll be Lordship allowed to give it to your Lordship, Lord, so that.
Yes, give them.
Right. So that let me not go back with the ignominy that I could not cite those judgments.
You give that to the judgments. Most of the judgments are known to me.
Right. Aye. And still for our satisfaction.
I'm reading that.
For our satisfaction and our client's satisfaction.
Sorry.
I mentioned nature.
Give them.
And your Lordship got that letter also. The only difference is in view of the prohibition contained after 2014, we could not. Prior to that, there was no prohibition.
You have to do it this way. Judgment, ratio, which paragraph?
He is do it.
That way, if you give, I will treat. Otherwise, I will not treat.
No, he will do it.
That's the requirement of Supreme Court. Supreme Court said the judges are not supposed to waste the time
by
just reading all these things. They should tell the bar if they give in the order, they will be looked into. Otherwise, they should not be looked into.
Correct.
I will not look into, at least.
We also do not look into, we only look at the relevant paragraph.
Correct.
But he will do
You
exercise.
prepare and do that. If you give that way, after serving copy on the other side, they will be part of the record. Otherwise, I will not read them at all.
No, I don't know whether how patch of flowers are there.
At least citation you give them.
But if anyone is here, I can. But he is there, he will give the copy.
No problem. Next. Yes.
open Hindi teacher man. Passover item. In item 11 man.
Item 11.
Again. Petitioner is the widow of a Hindi teacher, my lord, who died in 2023. After her death of her husband, her family pension papers have been submitted before the.
One second. Who appears for?
State assembly, my lord.
I am there. Not this.
No.
1 second. There is one judgment of the Apex Code. Right to residence under Article 19(1). Some, I don't remember some article, the class. Includes the right to apply for sites to the statutory bodies and get them. Get that judgment. Okay? Yes, brother.
Petitioner is the widow of a Hindi teacher, my lord.
Widow of a
Hindi teacher, my lord. Her husband died in 2023, my lord.
Why there is no practice of telling the dates at all? Died
yes,
last century.
I guess
something like that.
Synopsis and death chart date.
You tell that. I just like. Where is that synopsis?
Page 2, my lord. Synopsis, first. Index after index, my lord. A.
1415 RSAP benefit.
Given. That was they have recovered after 10 years. The death of her husband, after 2024, they passed an order to recover the amount he has received, that grad pay over 423 in 2013, my lord.
It is first time it has come or?
First time, my lord.
Let notice go, then they can answer that again.
My lord.
Otherwise, it is covered by Rafiq Masi as interpreted by this court.
This lordship also passes judgment of 3-9.
I know, my lord. Lordship may kindly have a look. What is the cause of action? Page 10, your lordship may kindly. Whose letter is this?
Page 10.
Yes.
6/2/2013.
Yes. 23/8.
Page 10.
2024. Page 10.
By order of the governor.
No. It is not there.
Hold on.
Page 10.
Call page 10.
Annexed?
Who filed it?
WPC 23985 11. After the service book.
Yes.
Your papers are not page 8.
Page 20, my lord. Page 20.
The letter of the DO, what he has given.
Yes. I have typed it. It is written in service book. This amount is to be recovered from her, and that was also recovered.
Typing down there.
Lordship, kindly see.
Typed
page 23, man.
Lordship, issue notice.
तुम्हें जो लिखी जो टाइप कॉपी लिखी ट्रिब्यूनल को छाड़ लो
first call this matter after 4 weeks. 4 weeks, and in the meanwhile counter if any may be filed.
Widow, my lord. Therefore, all amount has been recovered from her, my lord. 10 lakhs. Her husband's pen has been recovered. He is now in penny, my lord.
Wait, you'll file objection, then we'll treat. Yes, next.
Item 31.
Ah. 31.
ସବୁ କାମ କରୁଛନ୍ତି ଭୁଲ କରୁଛନ୍ତି ନିଜ ଭୁଲଟାକୁ ନିଜେ ମାନିବେ।
Three stories residential buildings. Call this which year matter? 20.
This is the year 2020.
What is that? He says that he should be permitted to put a 3-story
This
building.
is about the Cuttack Development Authority. This is in CDA, objection for approval of that construction. Residential building plan.
That is not approved.
Yes. They have made a 3-story building.
The petitioner and also panel counsel for the
Mr. D. Mahapatra, senior advocate.
are absent.
In the morning, he was there. I want to recapitulate the memory because of the throat soaring. I suggested if any other matter is there.
Correct.
So,
for this matter of the tools. Okay. You are right. Next.
Item 32.
In this case, I have prepared dead check. The petitioner have challenging the annexure 6 in the writ application, and where the transfer application was not allowed by the opposite parties. The lordship can go through the check.
Mahapatra appears in this matter also.
Yes, ma'am.
Then he is not well enough. Will that after 2 weeks?
Item 33.
But the point in not said, with the quick point here is, pursuant to a guideline, selection process was initiated, which contained a preferential clause. In terms of that clause, advertisement was issued, advertisement contained this preferential clause. We participated in the selection process. We got selected in the selection process. Appointment order was issued. We joined the post, meaning thereby, as per Tej Prasad Thakur recent judgment, the process starts from the advertisement, ends with the appointment. And we are appointed. We joined. Thereafter, the clarification was issued, changing the modality of selection, and on that basis, they terminated us. We challenged before this Honorable Court. Our termination was set aside. After it was set aside, it was obligatory on their part to allow us to join first, then take necessary action if at all is necessary. Without complying with the judgment or direction passed by this court, they again terminate.
No inquiry, nothing.
No, inquiry has been. The inquiry has taken.
So cause issued.
So cause notice was issued. So cause notice has been given.
Pursuant to the direction of this honorable.
So cause notice has been.
We have followed everything.
As directed by the coordinate bench.
My lord.
But the point is, subject to lordship will appreciate. As I said, my lord, selection process over after we joined and appointment was issued. Changing the rule of game after commencement of selection.
No, it's not.
After we were appointed, we issued a clarification. That to clarification is not in tandem with on the grounds on which you are terminating. Kindly see, now kindly see, my lord. Page 20 first. Take up 40644 of 23.
That is the last matter in the list.
But I am holding that first brief I am holding 37159.
No. Whichever he wants to argue. Because you are only opponent. He is nominous litis. He is entitled to
apply.
Kindly take up my matter because all the matters will be on the same point.
Okay.
40644 of 23.
Have you prepared any date?
Yes, sir. Yes, Lordship.
Just give that.
I don't know whether that list of date is in terms of my repeats or not. There are 6 to 7 dates only. I can give it. But that list of date may not match my page here.
That I will keep that in mind. 24/12/2021 will be the common date for all.
Yes.
Appeasement to all the district welfare officers are initiating the process
Very correct.
of recruitment. Then second one, you have left blank, 31/12/2021.
That is advertisement. That is the advertisement.
4/4/2022. Both dates.
Till point number 10, the dates are same. Till point serial number 10.
Let us see one by one. You give Mr. Lux that copy so that we can. Or you can mention from your own.
Right. Lord, 24/12/21, the guideline issued by the government for appointment of TGT. Lord, you may straightway turn to page 26 of my brief. Clause 6. bottom 3 lines.
26.
Page 26, clause 6, bottom 3 lines, my lord. Minimum cut-off mark. But you got it. Page 26. Clause 6, last clause of this page.
Selection procedure.
All selection of teaching staff shall be done through written examination. All selection.
Yeah.
Last 3 lines. Minimum cut-off mark of your category 35 and for reserve category 30. Out of total 100 marks, preference will be given to the candidates belonging to the same district. Preference will be given to the candidates belonging to the same. This is the guideline framed by the state. It was never
given to candidates belonging to the same district means what? No, it's not covered by judgment of the apex court.
Yes.
Apex court has said what is meant by giving preference, which is that judgment. Take out from Google.
Preference.
Yes.
Preference is
preference in the matter of appointment means what is discussed by the apex court. Anybody?
Already filed different government lordships in Eastern district filed by
all remaining equal. All 13 then these people will be favored. It's what apex court said. I remember because I.
That's not the issue here. That's not the issue. But then one just see, my lord. I'm just showing the facts here. After 26, my lord, advertisement was page 31.
Yeah, advertisement issued, you participated, your selection, you figured there, appointment order issued, you joined the duty. No dispute about that.
Thereafter,
it was cancelled and you approached this court.
Cancelled, my lord, kindly, that is important. Kindly see the clarification stated to be used against me. It is not the clarification which the state is using against me. What is the clarification? Page 52, my lords, may kindly see.
Before that, just I will have dates on admitted position.
That case, tomorrow I'll come back with the list of dates and done.
Wait, anyway, we have here, na? That's the only point.
That
you make out, Mr. Datta. I turn every page of every.
I know.
I have an art of reading first, just to be with very big humility. I say it. Very fast I read. I don't need so much time with generally others for reading. Okay, I read vertical reading. Mine is not horizontal reading. Anyway, of course, if you want, your time, no time. Nothing is going to happen with 1 week. You want it to argue next week?
I can next week, tomorrow, next week.
Tomorrow, I'm not very sure.
Next week.
Another matter.
Let it come after vacation.
No, we are terminated employees. We will do it.
No.
Doing service. Why after vacation? They are all appointed. They are enjoying.
No. What is there? You are given so cause you explain. This honorable court's judgment, single judge judgment has been complied. Admittedly, they secured less marks. And we people, with the alien people, opinion 5. We secured higher marks. That is the finding.
Well, there are arguments they have been appointed here after.
And preference, what the minor preference has been explained by 3 Supreme Court judgments.
You want
preference is not reservation.
On his feet. If you want time, I will give you also, no problem, whichever.
Let it come after vacation.
On 18th.
Again.
18th. Reopening. You written this week. On that day you can. Otherwise it may be used again here.
Already it's filed and it's on the top of the record.
You already filed it?
It's already on the top. It's in the list. Judgment man was saying that is Kailash Chandra Sharma. Supreme Court. Judgment was a preference on basis of residence that has been dealt with by Supreme Court in 2002 Supreme Court 387.
When it is time to
Sharma for the state of Rajasthan. Way back it has been decided.
Item 34. 34, madam, may I please your lordship know that matter. My dear, only one thing I want to point out. I am not asking for time, but I know my senior appearing for opposite party number 4, private opposite party number 4,
will say that I am taking a plea for time. Here, Mr. Mahapatra is for one of the contesting opposite party who has ordered my demolition, which is under challenge.
No, that we have ordered.
That's fine.
BMC order.
The declaration is by the. No, even if in his absence it can be heard, I have nothing to say. I can present it. There is no difficulty, madam.
Well, for your lordship's convenience, I have prepared a dead chat.
Yes, fine.
Have you shared it with him?
Yes, I will.
You share with him.
I will share it.
When your turn comes, I will go by that one.
Yes.
Okay. What happens? Every advocate will prepare his case in a particular way.
Yes.
So that is liberty. Right?
I have not submitted anything in my dead charts. I have only given the factual person.
He also cannot deny.
Yes. Which he cannot deny.
Yes.
Here, the challenge is to the two components. One, it is related.
What is the order? Just make a brandish statement.
The brief statement is this.
Yes.
A case was initiated with regard to unauthorized construction against our father. Though in the first place it should not have been against our father, it should have been against us, the petitioner. Be that as it may, it was initiated in 2000 and in 2009 we came into picture and we are allowed to be implicated as parties in that case. My entire endeavor would be to demonstrate before this noble court, though demolition, refusal of regularization has been passed, order has been passed, those orders have been passed by utilizing material which has not been supplied to us or for want of communication, thereby violating the principle of natural justice. And one more thing I beg to humbly clarify before proceeding further is, this is not a case of a typical builder making construction. This is a case of a private owner thinking of making a plant and selling it. Because he doesn't have any building antecedent or doing any building that way, like real estate.
He's not a real estate businessman.
No. But this was done way back in 1998. Now, this approval was in respect of two components.
Where is the impugned order?
And the impugned orders are under Annexure 1. I will come to that. Yes. Before that, if I can, I am not, this is under Annexure 1,
okay.
Then Annexure 5, Annexure 2 series, Annexure 3. These are the orders sought to be challenged. Little background with your lordship's kind permission.
Yeah.
My lord, after the proceeding was initiated, I have got an order sheet. I will produce and I will file it. That's a certified copy. So nobody will have a grievance.
Yeah.
Because the PTA authority is not here. My learned senior appearing for the BMC says I am sufficient to represent. So I will file that order sheet for your lordship's perusal also for appreciation whether principle of natural justice also has been violated or not and what way it should have been considered. Now, my lord, after this proceeding was initiated and we appeared in the meanwhile, in 2007, to be more precise on 31/12/2007, a scheme was floated for regularization of unauthorized construction.
31/12/2007.
31/12/2007. A scheme was floated for regularization of, that will be, if I am correct, that will be 2008. I'm extremely sorry, 2008.
No.
And that was in operation in 36/2009.
So that time-bound scheme was.
Yes.
31/12/2008 it came into force.
Yes.
And it expired on
36/2009. We applied on 36/2009.
Last date you applied.
We applied.
Within the period.
Here, one more thing I beg to point out to your lordship. A little simplification of fact will definitely assist your lordship. I can assist better. But the approval of plan was in respect of two blocks, Block A and Block B.
Each block comprises of how many floors?
No, I'll again clarify that. One is S+6, that is B block, which basically the opposite party number for the association is concerned. The other is A block, which in my humble submission, the association is no way concerned. The BDA authority, the municipal authority may be concerned. Now, so far as block A is concerned, one is S+6, one is state floor and +6, one is S+5.
A block, B block.
A block, B block.
A block comprises of
S plus 5. Steel floor and 5.
First one.
B block I also put a caveat that if I have committed any error on fact, I will stand corrected by the opposition.
I will also put a caveat. Do not commit any error.
No, I will not do it if at all. If at all. Unintentional, I'll only say. And I already never do.
S plus 6.
Yes. Now,
plus 6.
my lord, that contains, my lord, that contains 40 flats.
In B block.
B block. Now, my lord, so far as A block is concerned, I have been granted commercial permission. I'm clarified.
How many flats?
That's not a flat. They are, my lord, 2 rooms in each floor, 2 blocks in each floor. It's S plus 5. And we have taken commercial permission. Well, that is not part of the record. I'll produce that. And I hope BMC will or BDA will not dispute that. Now, what happens, your lordship will kindly note, 2000 the proceeding for demolition was initiated. 2008 the scheme comes into force. I applied on 36/2009. Now, my lord, they asked me to deposit the compounding fee of 1,27,786 and scrutiny fee of 300. I deposited. Now, my lord, the scheme provides that this should be decided in 6 months. Now, my lord, in fact, my lord, there are 2 proceedings I have said. One is with regard to demolition of my unauthorized construction. The other is with regard to the application I made for compounding or regularizing my construction. Now, my contention is raised that you have challenged
in one writ petition only.
One writ petition only. I'll explain that, man. The contention is raised that this is not maintainable because you are challenged in one writ petition. My submission would be...
That's all right. No issue.
Now, it is interdependent on each other in the sense, suppose your lordship accepts my contention that the order refusing regularization is bad in law for want of natural justice or whatever reason, then the consequential demolition will not be there. And in fact, in the UAP proceeding, that is the demolition proceeding, the authority had taken note of this, that I have deposited the compounding fee and that is order dated 9/7/2009. I'll produce the certified copy, the entire proceeding. Therein this deposit of amount and everything was taken note of, the court waited because the compounding is there. Now, though the scheme provides that it should be decided in 6 months, they waited for 4 years, about 4 years, 8 months. Then thereafter on 13/2/2014, it got rejected.
Suppose CPC says, every suit should be disposed of, preferably as early as possible. And there are some statute which say cases shall be, for example, every application shall be disposed of within 30 days. There is such a provision in CPC.
I'm not saying that it will vitiate. I'm only saying that it took
Factually time. Happened.
Factually it happened. I have never submitted my report.
Your first contention for invalidation of the impugned order. Please articulate.
I'll articulate that. Now, this order is based on a communication purportedly made to me by letter number 39420 dated 28/9/2013 to show cause as to why my application shall not be rejected. This application I have never received. So, question of me giving a reply would not arise because I have never been given that. So, once you are, because 2009 is the application.
No, now you have made the application.
2000,
you have remitted the money.
I have deposited the compounding fee, everything. So once you ask for compounding fee, and in my humble submission, subject to correction by your lordship, it's a question of a prima facie acceptance. But you ask, this is the fee. We are calculating your deviation. You deposit this amount. Well, I have deposited that. Now I will come to the deviation also, because that may be also relevant in the context of OP4, who is raising a grievance, the association.
One question. One question. What is the extent of deviation? What is the percentage of deviation?
I will point out that one. The deviation was twofold, as I find. In fact, deviation was that ground floor we had made some construction which is meant for parking. And in the top floor, because we had constructed up to 5 floors, I'll show your worship from the permission. In the permission, it was mentioned, subject to adhering to the other requirements, you can be granted 2 more floors. Of course, we have never applied for 2 more floors, nor we have got permission for 2 more floors.
But you constructed 2 more floors.
No. I have constructed only 4 rooms at the top. 4 rooms at the top. And they say that the parking is blocked by way of construction. That has been removed in the meanwhile. That is my statement. And there was a writ appeal against the interim order passed in this proceeding. There also it was clarified that that has been removed by the municipal authorities.
Is it true? That you will ascertain.
That your lordship will find out.
1 second. Who appears for municipal authority?
There.
Whether the parking is made free now?
I'll point. Oh, sorry.
It is not.
No, I'll just assist your lordship. First of all,
notice was issued, remained silent, did not reply. He has violated and he has totally opened the space.
And I will show whether the notice has been served or not.
Yes,
I asked only one question. When your turn comes, you can argue. I'm only clarification. He is saying we have removed every construction under the state floor, in the state floor.
Yes.
We will appoint one advocate who will go there and report it.
My lord, one more thing. That is the instruction I am submitting. That is always.
We can. Is there somebody so that I can see it in video phone only?
No.
In the video phone, mobile phone. I can see it now.
My lord, what is he saying now? Is there any affidavit to that effect is forthcoming?
Not necessarily.
Nowhere in the
One second. But whether there is a Mount Abu or not, it can be easily ascertained.
Yes.
By seeing it. If you file affidavit, Mount Babu has fallen down, then you have to show that. He has to show. Now I want to know, is there anybody in your property?
In fact, they are.
Ask them to call
they are
over mobile phone. Over your mobile phone. Over
the residents.
I can see that.
Lord, may I say
Those staying there, they can say because
Lord,
they have.
we are the Residential Owners Association. We are staying in that building.
Simple question.
Yes, ma'am.
Why do you want to complicate?
Yes.
We want to know. He says
Yes.
it is removed. If you say it is not,
Not an inch has been removed.
therefore show me over video phone.
Yes.
I will look into. It is open to the judge.
May I take it?
And show that over videograph.
Hon'Ble court କହୁଛନ୍ତି ଆପଣ ଟିକେ ଭିଡିଓ କଲ୍ କରିପାରିବେ ସେ ଜାଗାକୁ ଯାଇ?
Yes. Ask him to make the video.
remove it.
Show it to me. I'll show it to Behera and Mr. Mohan. Why
Those who are staying there.
in the event it is not done. If you do it before Saturday, at least one ground will be available.
ଆଜ୍ଞା ନାଇଁ ଆଉ ଯାହା ଯଦି ଥିବ may I take permission to tell him?
Yes.
କୋର୍ଟ କହୁଛନ୍ତି ଯେ ଯଦି ବି କିଛି ରହିଯାଇଛି if you can remove it by Saturday ସେଇଟା ବି ଗୋଟେ ground ରହିବ.
What ground will come?
I can tell it in English. My lord is saying that if you clean it, whatever is there, the garbage or whatever you clean, there will be one ground available.
So that I can go and have a cup of tea there with one of my friends. It's
Yes.
as clean as that.
Yes.
Not just to make it.
I just want to know one thing.
I will appoint,
Is he paying for plot or is he paying for the relief he seeks for?
Question is not that.
So therefore,
You have
when my lord is asking, I'm clarifying, my lord should be removed.
No, you have said to the court that your client has
Yes, remove.
every structure.
Remove.
Yeah, that therefore you should stand to that.
Yes.
I will appoint one committee now. Two lawyers will go there.
Yes. He says only the garbages are there, it has been removed.
Ask him. No construction.
Construction is removed. That's what. Construction removed.
No.
If it is false, then I will direct him
construction
arrest and
removed.
detention. Tell him, I will not so easily.
If you are giving a false statement, court is saying that you will be in detention. Construction सब removed. Only garbage are lying. ठीक तो correct statement. I'll come back, my lord. He's saying I'll come back with video and everything, videography of everything.
Ask him to come back now. Where from he has to come?
No, he Bhubaneswar.
Bhubaneswar. Ask him to come.
No, he's saying he's sending his brother for a videography and sending it.
It should reach now.
You make a video call. Okay, video call.
Video call and let the Mohanty see it, Behra see
This
it.
is
See that.
this is one part. I do not. I know.
I am not obstructing. I am not obstructing.
I have to take Abhimanyu.
No, you are not. You are not giving. Supposed to answer me. You are to answer the court.
Submitting for the court, not for you. I'm submitting for.
I will talk to you.
What I am saying.
This is a participating proceeding.
Yes.
You can't be that curt to your friend.
No, I am not.
You can tell your friend, brother.
I am not saying against anything against you.
That's all.
What I am saying that we are that apartment residential owners association. They are staying there. So therefore,
in the still floor, whatever is constructed is demolished. If not demolished, he will demolish it before Saturday.
Yes.
And clear all the garbage.
Yes.
Then thing will be clear.
Yes. Madam.
In the parking space.
Number one.
I actually do.
That is the parking space.
Yes.
Then
Both are using
we
it
come to,
parking
now
space.
you do it and come back.
Yes.
Madam.
Then we will hear you. We will not hear you again.
I'm so grateful, madam. I'm so grateful, madam.
And in the terrace.
And I'll come back to terrace to give you.
Otherwise, you will not have right of audience.
Yes.
Straight away your case will be.
Yes, my lord.
First you do it, then we may be heard in the matter.
Absolutely, my lord.
Absolutely.
Absolutely, my lord.
What will
Highly obliged.
There will come to that.
This file not over.
Anyway, we have to go floor by floor.
Yeah.
These are the two apartments.
We say that everything will be clear.
Yes.
That will record it.
Yes, ma'am.
Kindly ask your advocate on record to file a memo undertaking that everything will be clear on or before
Yes.
the evening of Saturday.
Yes.
File a memo now.
Yes.
Record in our order.
Yes, ma'am. And if that is not observed, I'll not be the counsel also. That I assure you.
Counsel and your client will not be there at all.
Absolutely.
In some other place.
I know your lordship, my lord. It has to be the court's, my lord, sanctity has to be maintained. And as an officer of court, I owe a duty.
Learned during the course of
But a memo
hearing.
From the state floor.
Learned senior advocate appearing for the petitioner. On the instruction of advocate on record, and also
client
as a client as well, submits with an undertaking that whatever constructions that were made in the stilt floor, contrary to the approved plan, shall be completely shall be completely cleared by demolishing. And also the garbage shall be removed so that the said floor becomes usable for the purpose for which the approval was accorded.
Yes.
Accorded. First, the petitioner is put to accorded, on or before Saturday will be 13, 9/2025. First, petitioner is put to warning that in the event this undertaking is breached, he runs the risk of arrest and detention at the hands of this court. Petitioner is also put to further warning that if undertaking is not complied with, he will not have right of audience and he will run the risk of non-suiting.
Yes, ma'am.
On that ground itself.
Yes, madam, because there is an undertaking, madam, before the Hon'Ble Court. And this is on telephoning instruction also.
It is open to the other parties to the proceeding to videograph the entire exercise and keep the same ready for the perusal of this court if need be.
Your Lordship may include the petitioner in that also. But I will produce.
Parties, all the parties.
Yes.
You can also video.
Interim order, Your Lordship may kindly estimate.
Interim order, subject to adherence to the above undertaking, is continued.
So kindly post the matter to
And Monday, my 13th, I am going for my parents' Swasti Visarjan.
When are you coming?
I will come back. Not on Monday, little after that. 2-3 days after that.
17th.
Tuesday. 17th.
That day for reporting, you need not be there.
If I am not there, my lord, I may be excused.
No problem.
But compliance will be there.
Compliance will be there. Otherwise, he runs the risk of. I am making it very clear. I will direct the Commissioner of Police to arrest you.
Apart from he running
this,
the race,
you should keep. I tell you, as a judge, it's my duty.
I would not.
See, also I can show. But where the builders are recalcitrant, and more often than not, they are. That's our experience. Troubling the flat owners, the occupants, all these things are happening. Apex Court has said about this.
I know.
Let alone this judge.
I gave this. I gave this statement with regard to clearance of the air only after taking instruction. I would not have given.
We will hear you.
And I also impressed upon him this has to go. So therefore, I have said that.
Very.
Then only I can beg for some kind of relief so far the other floor.
Let us see. Some kind of relief means you will be entitled to argue the matter.
Yes. Absolutely.
That's all.
Thereafter, my lord, thereafter it, your lordship will
correct. Law will decide.
Absolutely. 16th.
On 16th.
My is giving that memo.
16th. Yes. That memo you have to
that you will remove by Saturday. That
right. Ask your
yes.
You can't write. You
no, he will do.
Only advocate on record can.
No, he will do it. She will do it.
No. Oblige you that. Just show me the language. It should be very plain language. Now you have seen the whatever assurance you have given. I have recorded, and everything will be available online also. Everything will be available online also. Yes. Nobody can say I have not said that. This etc. Even judge cannot say. Everything will be available on.
Not necessary, man. We are. I can assure you. It is always like that. Any deviation is not acceptable to me.
A copy of this order shall be a carbon copy of this order shall be supplied to all the parties. Yes. Advocates appearing for the party.
We all are the officers of the court, so therefore we should.
Client is one part.
That's right.
But to be fair to the honorable court is definitely the first priority.
First, always it should be. My temple. Not only you, I should be fair to the court.
Yes.
And it's my duty. I am only a pujari here. Not beyond that. And it's my job. Whichever dictation he gives, I give dictation.
It is right from day one, it is like that, my lord.
But that time RERA Act was not there. That is why all these things
Anyway, give yield place to other advocates. Yes, give space to other advocates. Because they are also waiting. Yes.
Item 35.
On Tuesday. Hearing. Yes.
It
will be further hearing. It cannot escape my hands.
Item 35.
35.
Lordship.
Yes, Mr. G.
Prayer Lordship, kindly have a look to the prayer. Prayer was to allow the petitioner to continue in his appointed post of principal cum secretary of so-and-so college. But in compliance to that, government has passed an order on 4/9.
Yes.
Stating that in inviting reference to the subject cited above, I am directed to say that the Hon'Ble High Court of Orissa have passed an order on 24/7/2025 in WPC number 1572505 of 2024 with a direction to the opposite party number 1 to allow the petitioner to continue in his present place of posting till he retires on 30/11/2025.
Over.
In compliance to the aforementioned order, Sri Nikunja Bihari Mahapatra is allowed to continue at Sadhu Gaureshwar College, so-and-so Jajpur, only as a reader in English till he retires from the service on attaining the age of superannuation.
not the people.
That is the entire crux, my lord. My prayer was, I was appointed as principal cum secretary.
Yeah.
I was transferred from that post to a different college, your lordship. And this honorable court was pleased to pass and set aside the transfer order and allowed the petitioner to continue in his present place of posting till he attained the superannuation, your lordship. That order, they're saying they have complied. But what they have done is exactly what my fear was, and your lordship's fear, that they have demoted me from principal cum secretary to reader. And in this order,
he was principal.
Yes.
My lord.
His post as a reader will remain.
Yes.
But his position as principal has to be restored.
If he's, my lord, for reader, so for principal, my lord, from among that the seniority list of readers, from that list they were posted. So he will continue as a reader, and the principal, the senior most man will be there as principal.
Who is the senior most person?
Yes.
He was, my lord.
No, I am asking now, who is the senior most person there?
He is the senior most person.
Oh, that's all. Then he has to be restored. I will record your submission. Suppose if he is the senior most. Otherwise, again, one more case.
My lord.
We have other better business to do.
My lord, the issue, if I clarify, my lord.
You want to confuse me? The direction was, he should be restored to the office, privilege, whatever, which he had when he came here. That is the complaint. So he is not reader. Reader, he will continue. What is that you are giving?
In complaint.
And they have written only as reader. Rajiv, either going to punish me.
No, it's not a punishment. It is not that. There was a judgment passed by your lordships. In compliance to that, a merit cadre list was prepared of readers. So from amongst the readers, senior leaders, they were posted as.
Who is made principal now?
Principal is, there was one Umakanta.
Not that now.
He has left. Your lordship, the fastest. What will your lordship became?
Why only request you? Allow him to argue so that everything will be clear. Order says, order is very clean as Gangetic waters.
My lord, your lordship.
Therefore, whether your officer wants to comply with that order or I should direct.
No, let me take instruction. Day after tomorrow or coming week.
On the submission, I am the OP number 4 in this writ petition, but I have retired on 31st August. So my name may be deleted from the writ petition.
Then nothing remains to be adjudicated.
Let us wait. Next thing. Any difficulty?
We have no claim in this. We have no say in this writ petition.
That's what we have noted, that no adverse order will be passed against you. Okay. Mr. G, there appears to be some mischief from some quarters.
No. There were two persons.
Therefore, I said appears.
My lord, there were two persons. 4
has retired.
He was the senior most.
And he was appointed as principal. Now he is the senior most person.
My lord.
Again, one more case.
No. We shall solve this problem here.
Whoever is senior. If he is not, you did not. If he is not senior, you need not.
My lord.
Senior most person should be placed in the office
as principal.
There again, I will not allow doing of business at the hands of officials.
No.
Yes. Yeah. Father, day after tomorrow. And take this. So this we are giving you back. This will not satisfy me.
My lord.
Another letter you have to bring. Otherwise, only litigation. No relief will reach the litigant at all.
Item 36.
Item 36.
I don't know.
All this matters from other date.
It is relating to that B.Ed admission.
Generally,
The admission is.
Generally, G will not ask. Government advocates do not ask time at all.
No, madam. What I am submitting is already admission is over. Now classes has been started. On the last occasion, Your Lordship is directing to allow me to.
You are going to class now?
No, madam.
You are not permitted to go to class?
No, madam.
He is not admitted.
Yeah, I am not admitted.
That's why I'm
But in the
asking for-
event he loses,
My lord.
in the event he wins, he should not be prejudiced. Saying that I lost the class. In the event it is dismissed, no question. In the event he is allowed, what should happen to the tuition? Therefore, I wanted to direct the OPs to permit him to sit in the classroom. Otherwise, he will be a road Romeo,
My lord,
which we don't want to happen.
Let's me direct that. I have no problem.
Yes.
But simultaneously give me some time so that
OMR seat should have been brought there.
Petitioner shall be permitted to sit in the classroom. Which classroom you want to?
Solawala Women's College in B.Ed.
In B.Ed class.
Solawala Women's College.
Pronunciation.
without prejudice to the
Without first, this arrangement is subject to the condition that equity shall not be pleaded on this basis.
They may comply the previous order. Your Lordship is directed.
In the meanwhile, the order dated 13/8/25.
Yes, my lord. 13/8/2025 as well as 21/8/2025.
Orders dated 13/8/25
and
21/8/2025 to be
continued.
complied. Continue.
Yes, my lord. Your Lordship has kept one seat vacant there.
Or continue. Okay.
And they have to comply the same. They have to bring the OMR seat original one that has not been brought till now.
Complied and continued.
Yes, ma'am. Obliged.
Call this matter on
any date, my lord.
23.
23, my lord. Yes.
All right. You ask your client to go and sit in the classroom.
She is the daughter of my colleague only.
Let her sit.
Item 37.
I may be pardon your lordship.
Yes.
Lordship, in this matter, lordship, I am being led by my learned senior Mr. Gautam Misra. Lordship, he has to rush to Bhubaneswar for a personal difficulty, your lordship. Lordship, and lordship, I am praying let it come on Friday, your lordship.
Well, the interim order is operating against me. I succeeded in the tribunal, and pursuant to the order of the tribunal, my appointment has been approved. But I am not getting granted it because of the interim order.
Lordship, inter se seniority is in dispute. Lordship, only I am praying for Friday, your lordship.
We will argue on Friday.
Lordship.
This is of which year?
Lordship, 2018.
2018.
2018. This is an inter-se dispute between the petitioner and the opposite party number 4 for the post of peon.
And it has nothing to do with your this one at all.
Lordship, both are
because of this order you are suffering.
Yes.
Lordship, both are engaged. Only who will be at the higher post, your lordship.
The director. I succeeded in the tribunal.
We will call this matter tomorrow.
Yes.
Lordship, tomorrow and day after tomorrow he will be in Delhi, lordship. Lordship, Friday, lordship.
We will call this matter on 16?
Lordship.
16 October.
No, 16 September.
16 September, I have difficulty. 18 September you can have.
18 September.
18 September.
Lordship, may I pray, lordship, let it not be taken up on Wednesday and Thursday, lordship.
When I was a child, I saw one movie relating to Bhakta Prahlada. That Bhakta Prahlada, the Hiranyakashipu had a boon, saying that he will not be
day and night, morning and
he will not be killed during night, he will not be killed during day, he will not be killed inside the house, he will not be killed outside the house. Therefore, he was placed on threshold.
I'm sorry, Lord.
Anyway, choose one date.
16th, 17th.
Whichever date you choose from the calendar, that day you should be ready.
Lordship, 15th.
15th. All right.
Yes.
Item 38.
My lord, this is a case. On last occasion, my lord, I addressed before your lordships. This is covered by a judgment of the coordinate bench of this honorable court. This is a case of 110 girls' high school. My lord, so far as 110 girls' high schools are concerned.
110 girls' high school means?
My lord, they have been categorized as
that way.
110 girls' high school or 100 high schools initially, subsequently 10 were added. My lord, these 110 girls' high schools or 100 girls' high schools, those schools are eligible to receive grantinate from the state government prior to 1/6/1994 as per the executive instruction issued by the state government way back in the year 1979. But after coming into force of the grantinate order of 1994, they are coming under category, they are coming under para 7 or order 7 of the grantinate order of 1994. As per para 7 of the grantinate order of 1994, my lord, a school which has become eligible to receive grantinate from the state government as per the previous executive instruction, they will get grantinate irrespective of their eligibility at the rate of 60% with effect from 1/6/94 if they have been eligible at the rate of 60% by 1/6/94 and at the rate of 100% grant if they are eligible by 1/6/1994. All these schools, all these 100 girls' high schools come under that category. Proposals were sent, but those schools were not notified to receive grantinate from the state government with effect from 1/6/1994 as per the grantinate order of 1994. Similarly situated schools were notified. And out of these 100 girls' high school, almost 60-70 schools have already got grantinate as per the grantinate order of 1994. Some cases even went to the Honorable Apex Court, and the Honorable Apex Court also upheld the judgment of the State Education Tribunal and this Honorable Court. Some schools were left out. Well, what has happened to these schools? After the grantinate order of 1994 was repealed, due to coming into force of the grantinate order of 2004, my lord, initially these schools were notified to receive block grant as per the grantinate order of 2004 with effect from 1/1/2004. Then subsequently, an amendment was incorporated in the grantinate order of 2004 relating to these schools, these 100 girls' high schools, that these schools will get all other benefits with effect from 1/6/1994 because they are eligible to receive grantinate from the state government with effect from 1/6/1994 as per the grantinate order of 1994, including increments, revised scale, etc., etc. But they will get block grant from 22/9/2000, 100% block grant from 22/9/2007.
22/9/2007.
22/9/2007, because the amendment was incorporated in 2007. Your Lordship may, for a moment, your Lordship may kindly see that.
Now, what is the order that you
are? The order I am relying upon, a coordinate bench of this Honorable Court.
Now, what's the impugned order?
But the impugned order here is, here of course my case was decided on, my lord, my case was negatived on merit by the learned tribunal. The learned tribunal has held that applying para 11, 12 and para 16 of the grantinate order of 1994 has held that our school is not eligible to receive grantinate as per the grantinate order of 1994.
Why?
My lord,
which
your lordship may kindly come to Annexure 4.
Annexure 7. Annexure 7.
No, sorry. Annexure 7. Page 47.
Yeah.
Page 47. Your lordship may kindly come to paragraph 6.
Paragraph 6.
Paragraph 6.
Before that, your Lordship may kindly see para 5, page 52. From the record, it appears the school got recognition to impart education in class 8 in the academic session 89-90. The first batch of students of the school was allowed to appear in the annual high school certificate examination as regular candidate in the year 1992. The eligibility for receiving the grantinate in terms of grantinate order 94 is governed under para 11, 12 and 16 of the said order. For better appreciation, the relevant paras are extracted below. But these paras are not applicable to the case of schools which became eligible to receive grantinate with effect from 1/6/94. Then your Lordship may kindly come to para 6.
These paragraphs are not applicable.
Not applicable because those schools which became eligible to receive grantinate after 1/6/1994 or those who are not covered under para 7, for those schools, these paras are applicable. Your Lordship may kindly see, then your Lordship may kindly see paragraph 6, then I will take your Lordship to 1994 order. Para 6. In view of the aforesaid requirement prescribed under para 11, 12 and 16, for acquiring the eligibility to receive grantinate, it is now required to be determined as to whether the applicant school had been satisfied the conditions or not. From the record, it does not appear. The school in question is a girls' high school of the concerned Gram Panchayat within the permissible limit in terms of para 11B. My lord, wherefrom he got it? From the statement of appearance of the students in the annual high school certificate examination from 91-92 to 2006-7, it appears first batch of students of the school had appeared in the year 1992 and continued to appear till 2007. Under para 12, a school situated in educationally backward district or a girls' high school may be considered for minimum grantinate after 1 year of presentation of candidates at the annual examination and grantinate equivalent to 100% 2 years after receipt of such minimum grantinate. In this case, after appearance of students in 1992, the school was eligible for minimum grantinate from the year 1993 and full from the year 1995, subject to further compliance to the mandatory requirement of clause 16 Roman 4 of Grantinate Order 94. From the roll strength statement, it appears there were adequate pupils in each class in the year 92 to 96 only, but not in subsequent years. That apart, the percentage of result was below 50% of the state's average for the year 92 to 98, 2000 to 2004. Thus, the school in question does not satisfy the mandatory requirement of clause 11 and 16(4) of the Grantinate Order 1994. Therefore, the school is not eligible to receive grantinate in terms of the Grantinate Order 1994. Hence ordered, the JA application being devoid of merit is dismissed.
Yes.
Now, your Lordship may kindly come to the Grantinate Order of 1994.
That I'll come to. But before that,
yes,
whether this passing percentage,
yes,
which the learned presiding officer of the tribunal say,
yes,
is it true or not?
Pilot,
we don't dispute that.
No, my lord. So far as passing percentage is concerned, we have fulfilled the conditions of passing percentage because the result of that school is more than 50% of the board's average.
That means this is contrary to your records.
Yes, contrary to the materials available on record. That is my first point.
Where have you taken contention?
My lord, your lordship may kindly come to, even for girls' high school, that is not required. Even if it is required, my lord, I have given that.
This finding is without any basis.
Without any basis, but even if it is applicable, then also we fulfill that condition. Your lordship may kindly come to.
In other words, even if that finding is left intact, still you are entitled.
Still we are entitled.
Criteria, the parameters of entitlement.
Well, at entitlement, your lordship may kindly come to Grantinate Order of 1994.
In this book,
yes, in that manual that is there, page will match. 537.
537.
My lord, may kindly come to page 538. The nomenclature of that order is the Odisha Education Payment of Grantinate to High Schools and Upper Primary Schools Order 1994. Correct. My lord, may kindly come to para 7. Our case is covered under para 7.
The educational institution.
The educational institutions which have become eligible to grantinate on the basis of the executive instructions in force immediately preceding the date of commencement of this order, but have not received any grantinate so far, may be paid minimum grantinate at the rate of 60% of the salary cost of the teaching and non-teaching employees, hereinafter called minimum grant, from the 1st June 1994, irrespective of the date from which such educational institution would have become eligible under the said executive instructions. Grantinate payable shall be worked out with reference to the initial pay in the relevant scale of pay as on the 1st June 1994. No such arrear shall be paid, provided that in the event of any educational institution would have become eligible for 100% grantinate from any date prior to 1st June 1994, grantinate may be sanctioned at 100% of the salary cost of the teaching and non-teaching employees, hereinafter called full grant, from 1st June 1994. My lord, our school, being a girls' high school, my lord, became eligible to receive grantinate from the state government as per the previous executive instructions of 1979, which was in vogue or which was in force by
94.
Yes, that is after presentation of one batch of candidates at the annual HSC examination. The first batch was presented in 1992. Therefore, our school became eligible to receive grantinate from the state government with effect from 1/6/1993. That means prior to 1/6/1994.
Under which instrument it is?
As per executive instructions of 1979.
Sure, sir.
Well, that is, I have annexed that. This is also available in this book. I have also annexed it. Page 56. My lord, may kindly come to page 56, annexure 8 series. 8 series, the 8 series.
Yeah.
This is the executive instruction or resolution which was, my lord, in vogue. Or
this order issued 1994 order.
Yes, that is under section 7, under section 7C of the Orissa Education Act in 1994. After there was no statutory provision. There was no statutory provision regulating payment of grantinate.
They were all executive instructions.
All executive instructions. Therefore, in para 7, the executive instruction has been, the word executive instruction has been employed.
Correct.
My lord, may kindly see that executive instruction at page 56. Paid principles of grantinate to non-government aided high schools. My lord, may kindly come. Yes. My lord, may kindly come to page 57 first. Running page. That is 10(1). A recognized high school will be eligible to receive minimum grantinate after 4 years from the year of presentation of candidates in the final high school examination, subject to the following conditions. A, if it is a 6th class high school, it must have at least 200 students on its rolls. And if it is a 4th class high school, because by then class 11 was there.
Then 40 students on its rolls.
It must have at least 40 students.
One second, this way.
Your Lordship's kind permission. Only your Lordship may peruse. I hope
Just
it
one
is
second.
confirmed.
Just give that. Give copy of the memo. But you have not mentioned anything about the garbage removal.
Everything, madam.
No,
Yeah,
that's
sure.
not mentioned.
That will be mentioned, madam. It will
Mention that. I need to put it.
Everything will be done, madam. I assure your Lordship.
Just mention that.
I have already passed on the message and I have also impressed upon him the consequences also.
Consequence you should tell.
Inform him. And even I have told him if necessary.
He will not be in that home. he will be in some other place. You tell him.
And that has to be to uphold the majesty of the honorable.
That's
court.
what. Yes. Then when you have written one.
A recognized high school will be eligible to receive the minimum granting aid after 4 years from the year of presentation of candidates. This is for general high school, not for girls high school. I will take your lordship to that provision. After 4 years from the year of presentation of candidates in the final high school examination, subject to the following conditions. A, if it is a 6th class high school, it must have at least 200 students on its roll. And if it is a 4th class high school, must have at least 140 students on its roll. By then, my lord, class 11 was there. Subsequently, it was. Then B, the result of the school.
6th class high school means up to 6th standard.
No, 6th class high schools mean, my lord, 6, 7, 8, 9, 10, and 11.
6, 7, 8, 9, 10.
10 and 11. Now 11, now there is no 11, only 10. Now 5th class high school. 5th class high school is there. Then another kind of high school, that is another type of high school, that is 4th class high school means 8, 9, 10 and 11. Now only 8, 9 and 10.
7, 8, 9, 10.
Yes. No, 8, 9 and 10.
Only 3.
So,
because 11 is not available.
7 and 8, that has been correct. Then your lordship may kindly come to B. The result of the school must not be at any rate below state average in the annual high school examination for 3 consecutive years by the time it qualifies to receive the minimum granting aid. State average means the board's average. That has been in section 7D, it has been provided. Then your lordship may kindly come to the note portion. However, the last paragraph. However, in the educationally backward areas, the minimum granting aid will start after 1 year of presentation of candidates in the final high school certificate examination, and the roll strength in the, that is final high school, that is 6th class high school, and a 4th class high school must be at least 140 and 100 students respectively, and the result of the school must not be at any rate less than 25% below the state's average in the annual high school certificate examination. Since it is a 3-class high school, the girls' high school is this provision meant for
8, 9, 10.
Yes, 3-class high school, 8, 9, and 10. Well, so far as this condition is concerned, which is, my lord, meant for educationally backward areas, this applies mutatis mutandis to girls' high schools. Your lordship may kindly see the next page.
It need not be on a state average. It can be less.
The concession mentioned in the above paragraph will also be made applicable to girls' high school all over the state.
So, on girls' high school or on par with the scheduled high schools?
Yes, scheduled high schools. Well, so therefore, well, if 100 students for 4-class high school, so far as 3-class high school is concerned, well, the minimum roll strength in each class is 25.
So it will be correspondingly reduced.
And so far as the state's average is concerned, that is percentage of board is concerned, that is 25%, not 50%. And this 25% was further relaxed by virtue of another executive instruction, my lord, from a retrospective date. That is at page 60. That is the resolution dated 23rd September 1981. Principle of granting to non-government aided high schools. In the Education and Youth Services Department resolution number such and such dated 17th March 1979, my lord, the resolution which I have referred to, read with resolution number such and such dated 31st October 79, government fixed up the principles of granting aid for non-government aided high schools in the state. After enforcement of the aforesaid resolution of government, received some representations from various quarters for assigning the qualitative and quantitative criteria in the above resolution on the ground is that a strict application of the criteria would debar a large number of schools from receiving grantinate even after 4 years from the date of presentation of candidates and may restrict any hinder growth of education in the state and more particularly in its educationally backward areas. After careful consideration, the government have been pleased to decide that grantinate to non-government aided high schools need not be subject to qualitative assessment of the school performance. For the present, this will be effective with effect from 1st April 1979.
For the present means?
For present means, my lord, it has got retrospective effect from 1st April 1979. Your lordship may kindly see that very resolution, 17th March 1979, my lord, that was issued on 17th March 1979. And that was in effective from 1st April 1979. So therefore, my submission before your lordships is, so far as girls' high schools are concerned, which are covered under Para 7 of the Grantinate Order of 1994, for them, my lord, so far as roll strength is concerned, that is 25 classes per week, that is 25 classes per, my lord, 25 students per class. And so far as presentation of candidates is concerned, if both the circulars are read together, then my lord, there
exempt them from that.
They are exempted. This is my first plank of submission. Even assuming for the sake of argument that a tribunal has applied the rigors of Para 11, 12 and 16, my lord, may kindly see Para 11, whether it is applicable to our school or not, girls' high school. Those schools which, girls' high school are schools which became eligible to receive grantinate before 1694.
The educational institution.
My lord, 539. The educational institutions which have not so far been eligible to receive grantinate, or the educational institutions which may be established hereinafter shall receive grantinate in the following manner. Then other things are there. Then Para 12. The eligible high schools coming under the category described in Order 11 may be considered for sanction of minimum grantinate equivalent to 60% of the admissible salary cost of the teaching and non-teaching staff of such educational institution as per the staffing pattern, yardstick prescribed by the government after 4 years of presentation of candidates in the annual high school certificate examination conducted by the Board of Secondary Education Orissa, and grantinate equivalent to 100% of the admissible salary cost of such staff 3 years after receipt of the minimum grantinate. Then high schools located in educationally backward districts and girls' high schools may be considered for sanction of such minimum grantinate equivalent to the amount stated above after 1 year of presentation of candidates in the aforesaid examination, and grantinate equivalent to 100% of the admissible salary cost of the staff as stated above 2 years after receipt of such minimum grantinate. The criteria applicable to high schools and mutandis applied to tolls and madrasas conducting corresponding courses.
Yes.
So my submission before your lordships is, our school being a girls' high school which has become eligible to receive grantinate prior to 1/6/1994, that is covered under Para 7, not as per Para 11, 12.
Which the tribunal mentions.
Yes. And now your lordship may kindly see, even the tribunals, my lord, if the tribunal's wisdom is, my lord, accepted to be correct, then also your lordship may kindly see the roll strength and presentation of the percentage of pass, my lord, Annexure 7 at page 44. Page 44. Running page 44. My lord, may kindly see. This is the roll strength I have given starting from 89-90.
30, 75.
Class 8 first it was opened. Then my lord, class 9 was added 1991, 91-92, 8, 9, 10. 40, 49, 27, then 92, 93, 40, 33, 26, 93, 94, 25, 25, 25,
All they are except one, 96, 97.
96,
Class
97.
10 is only 11.
Class 10, by then the petitioner school has already become eligible.
It has
It
already.
is after presentation of one batch. That is by 1/6/1994, our school became eligible. That is after. And so far as percentage is concerned, my lord, may kindly see the next page. This is of the board's average. Total strength 27, total number of students appeared, total number of students passed, percentage 30.76. Board's average is 56.6. 50% of the board's average, that is the requirement under the Education Act that has been provided under section 7D
Of the 69 Act.
69 Act. My lord, may kindly come to page 141. That is the provision for withdrawal of granting aid. That was also incorporated in 1994 by way of amendment. The prescribed authority may withdraw the granting aid of a private educational institution if one, the regulation of the institution has been, the recognition, that is a printing mistake. The recognition of the institution has been suspended or withdrawn. Then Roman 2, the percentage of students passing the annual and supplementary examination conducted by the Board of Secondary Education or the Council of Higher Secondary Education or the concerned university, as the case may be, falls short of half of the percentage of students passing such examination for the entire board or the council or the university, as the case may be, for 3 consecutive years. That means the result should be 50% of the board's average. Because it is a high school, board is applicable. Now your lordship may kindly see, and this is the only high school of
Board's average.
Board's average. But if the result of the board is 50%, then the school must 25%. That is the 50% of board's average. Then your lordship may kindly see the granting aid order of 2004. Because after repeal of the granting aid order of 1994, although these schools were eligible to receive granting aid as per granting aid order of 1994, my lord, may kindly see the granting aid order of 2004. Page 470.
470.
470. This was also framed in pursuance of subsection 4 of section 7C of the Orissa Education Act, 1969. Your lordship may kindly see the first paragraph. In exercise of the power conferred by subsection 4 of section 7C of the Orissa Education Act 69, the state government do hereby make the following order to regulate payment of granting aid to private educational institutions being high schools and upper primary schools, etc. namely. Then your lordship may kindly see
one small grammatical thing very often I am seeing in this one. See, the state government do hereby. State government is a singular. Why in many statutes and other things they say that do hereby instead of does hereby?
My lord, I have also come across.
I have seen many central.
Yes, in central act.
Of very old acts also.
Old act. Do hereby.
Yes.
Then your lordship may kindly see the amended provision, Rule 4. Rule 4 or Order 4, quantum of block grant. This was incorporated by virtue of the amendment made on 6/10/2007. It was substituted. The quantum of granting aid to 100 girls high school. Our school comes under 100 girls high schools.
Yours is 110.
No, 10 were subsequently added. We are coming within 100. The quantum of granting aid to 100 girls high schools notified by the government in School and Mass Education Department notification number such and such dated 20th February 2004, it was first time notified. On 20th February 2004, institution was notified to receive block grant with effect from 1/1/2004. Subsequently, this amendment was incorporated and that was cancelled. Being aided educational institutions under subsection B of section 3 of the Orissa Education Act 69 and which have presented at least one batch of students in high school certificate examination by first day of June 94 shall be the amount representing the initial pay of the, Your Lordship may kindly see the cut-off date. One batch of students in high school certificate examination by the first day of June 94 shall be the amount representing the initial pay of the teaching and non-teaching employees of such schools on that date in the pre-revised scale of pay, including increments from 1/6/94, notionally accrued as on the date of notification, plus the dearness allowance as admissible thereon. Then Your Lordship may...
No, what is meant by this?
My Lord, my submission before Your Lordship is subject to Your Lordship's acceptance. My Lord, so far as 100 girls' high schools are concerned, since they are eligible to receive grantinate with effect from 1/6/1994, as per grantinate order of 1994, and they are covered under para 7, my Lord, they will get notional increments and pre-revised scale, etc., including other service benefits from 1/6/1994, but they will get block grant, 100% block grant from 22/9/2007. That is contemplated in the explanation portion, the next page. The 100 girls high school, this was also incorporated by way of amendment. The 100 girls high schools coming under category of clause 1 of order 4 and 169 high schools coming under category of clause 4 of order 3 of grantinate order 2004, notified by the government in school and mass education department notification number such and such, dated 20th February 2004, which warrants cancellation and re-notification pursuant to relaxation allowed under the Orissa Education Payment of Grantinate to High Schools, Upper Primary Schools, etc., Amendment Order 2007, enabling them to be eligible under this amendment order, irrespective of the date from which such educational institutions would have become eligible under Grantinate Order 94. Grantinate Order 2004, as the case may be paid grantinate and the quantum of block grant as determined under clause 1 and 2 of order 4 of grantinate order 2004, as the case may be, with effect from the date of issue of the re-notification under the Orissa Education Payment of Grantinate to High Schools, Upper Primary Schools, etc., Amendment Order 2007. Then 2, the quantum of block grant payable to a private educational institution which has become eligible to receive grantinate after the first day of June 94 shall be such and such amount per high school per annum, which includes provision for one watchman and other things already in receipt of block grant with effect from 1/4/2008. Similarly, the amount of block grant being paid to each UP school, we are not concerned with that. Then explanation. For the purpose of this clause, emoluments shall mean the initial pay
of the dearness allowance.
Yes, my Lord. Pursuant to this amendment order of 2007, all these schools were re-notified. My Lord, Your Lordship may kindly see the approval order I have annexed. Although I have not annexed the notification.
All this has not been considered by the tribunal at all.
Not considered at all. And my Lord, Your Lordship may kindly see the approval order. What is approval order to the region? Oh, approval order. Page 22. My Lord, may kindly see that. Page 22. Office of the Inspector of School, Jajpur Circle, Jajpur. 14/3/2008. In pursuance of government notification number such and such dated 22/9/2007, that and it letter number such and such of the Director Secondary Education Orissa dated 23/11/2007 of the School and Mass Education Orissa, the appointment of the following staff of your school is hereby approved provisionally in the following manner in order to release block grant in the pre-revised scale of pay with effect from 22/9/2007, taking into account the initial pay
as on 1694.
notionally as per Orissa Education Amendment Order 2007. This is relating to our school. But by interpreting all these things, but the coordinate bench of this Honorable Court, my lord, delivered a comprehensive judgment.
What details
you share with your
already I have given that it is. Put a photo. My lord, may kindly see. 4.9. My lord, may kindly come to page 16 of that judgment. Everything has been discussed. It is however contended that it is however contended that while the matter stood thus, Granting Aid Order 94 was repealed with introduction of Granting Aid Order 2004, so notified on 5/2/2004. However, Granting Aid Order 2004 was further amended by notification dated 10/9/2007, which I have shown to your lordships.
Yeah.
By the said amendment, the following provision was included in para 4.1 of the order that has been quoted.
Yes.
Then your lordship may kindly come to para 4.8. It is contended that in terms of the amendments so notified on 10/9/2007, by notification dated 22/9/2007, government in the Department of School and Mass Education published the list of 100 girls' high schools eligible to receive Granting Aid under Granting Aid Amendment Order 2007. While publishing such notification on 22/9/2007, the
earlier notification
issued by the Self-Serve Department 22/2004 was cancelled. That has been mentioned in that explanation. It is however contended that though initially 109 unaided girls' high schools were held eligible to get the benefit of Granting Aid under Granting Aid Order 94, and out of those 109, 5 girls' high schools were held entitled to get the benefit by notification dated 4/7/98, but another 4 girls' high schools were also held entitled to get the benefit under Granting Aid Order 94, and thereby leaving 100 unaided girls' high schools to get the benefit so notified, initially by notification dated 22/2004 and subsequent notification issued on 22/9/2007. It is contended that in terms of the amendment provision contained under 2007 amendment order and the notification issued by the department on 22/9/2007, services of the respondents was approved with effect from 1/6/94 by the office order number such and such of the then Inspector of Schools, Cuttack Circle, relating to that school, even though the services of the respondents were approved with effect from 1/6/94, but they were held eligible to receive Granting Aid in shape of block grant with effect from 22/9/2007. That is also reflected in our approval order. The date of notification issued by the government in declaring 100 unaided girls' high schools to receive the benefit under amendment order.
All contentions.
Yes. Then learned senior counsel appearing for the respondents. Your lordship may skip over all those things. Now your lordship may kindly come 4.16. In terms of such notification issued on 22/9/2007, though the respondent institution was extended with the benefit by the office order dated 8/2/2008 by taking the date of appointment as 1/6/94, but block grant was released with effect from 22/9/2007. Our case is akin to that. However, out of those 100 girls' high school, basing on the order passed by the tribunal, so confirmed by this court as well as by the Honorable Apex Court, 29 girls' high school on the face of the extension of the benefit under the amendment order 2007 were extended with the benefit of 94 order by notification dated 24/6/2007. Not only that, while implementing similar order passed by the tribunal, so confirmed by this court, benefit has been extended in favor of other girls' high school similarly situated. It is accordingly contended that since out of 109 schools, initially 9 schools and subsequently another 29 girls' high schools have been extended with the benefit of grantinate.
Even again, that is contention only.
My lord?
All this is contention only.
Yes, then your lordship may kindly come to para 4.18. It is contended that since petitioners are similarly situated, that Arvinda Srivastava case has been quoted.
Reliance was also.
Then C. Lalita case has been quoted in para 4.19. Then my lords, other cases have been quoted. Then your lordship may kindly see. My lord may kindly come to para 6. Having heard learned counsel for the parties and considering the submission made, this court finds that claim in the present batch of appeals is with regard to claim of employees or institutions of different unaided girls' high schools functioning in the state to get the benefit of grantinate under grantinate order 94. As found in terms of para 12 of 94, order 109 girls' high schools were initially held eligible to get the benefit of grantinate under the 94 order. Accordingly, proposal was submitted by the Director, Secondary Education before the government by its letter dated 29/6/95. Basing on such recommendation made by the Director, out of those 109 unaided girls' high schools, 5 girls' high schools were held eligible to get the benefit of grantinate under grantinate order 94. By notification dated 4/7/98. Not only that, 4 other girls' high schools were also held eligible to get the benefit under grantinate order 94. On repeal of the 94 order with coming into force of the grantinate order 2004 and 5 to
6.4.
Yes. However, it is found that in terms of the order passed by the tribunals, so confirmed by this court as well as by the Honorable Apex Court in different civil appeals, government by notification dated 24/6/2017 extended the benefit of grantinate under 94 order in favor of another 29 girls' high schools. It is also found that in terms of the order passed by the tribunals so confirmed by this court as well as by the apex court, such benefit has been extended in favor of the employees in grantinate case number such and such, grantinate case number such and such, so on and so forth, on the face of such notification issued on 22/9/2007, and the extension of benefit under 94 where similar order passed by the tribunal is under challenge. This court is also inclined to set aside the judgment in such appeals where similar claim has been rejected by the tribunal. While allowing and dismissing the appeals, this court directs the state missionaries to extend the benefit of grantinate under grantinate order 94 in respect of the employees or institutions in the present batch of appeals who extended by notification dated 24/6/2007. This court directs the state missionaries to complete the entire exercise within a period of 4 months from the date of receipt of this order. But because of the wrong findings of the tribunal, my lord, so far as the petitioner's case is concerned, that has been rejected. Because we fulfill the role strength, we fulfill the, so far as passing a percentage as per the board's average is concerned. And although our 79 resolution read with 81 resolution is applicable.
No, it's not right. You cited this decision.
Yes.
For proposition. What is the proposition emerging from this decision?
But the proposition is,
fact-based it is.
Well, so far as 100 girls' high schools are concerned, these schools form a separate category. They are eligible to receive grantinate as per the grantinate order of 1994 and their cases are covered under para 7. Because these schools became eligible to receive grantinate as per the previous executive instruction
of
79 and 81. And so far as para 11, 12 and para 16 are concerned, that is applicable to new schools which became eligible to receive grantinate after 1/6/1994. Applying para 11, 12 and 16, the tribunal has rejected our claim, although even para 11, 12 or 16 is applicable, then also our institution fulfills the eligibility condition.
Firstly, those paragraphs are not applicable at all to
at all.
Is your first contention.
Otherwise, our institution would not have been notified as a girls' high school to get
benefits on par with scheduled schools.
Yes. This is my contention.
Yes, what do you say?
My lords, kindly grant me some time to give the reply. Yes.
In the meanwhile, Mr. Spain,
I will give a, yes, date chart with written note of submission. Yes.
Note of
Sir,
right.
This matter is under order 41 rule 11. So in a nutshell, in one line, I will submit, he will submit letter, my lord. Lordship may kindly have a look to the granting order 2004, 473 page.
473.
473.
Yes. Manner of submitting application.
Yes, my lord. Last 7. Repeal and 7. The Orissa Education Amendment of Granting Aid to the high schools, upper high schools order 19 is hereby repealed.
Repealed. Okay. Provided that. Proviso is there.
Yes. That's it. Provided that the private educational institutions which are in receipt of granting aid
94
from government order to
you are not in receipt of any granting aid at all.
No, they are not. My lord, let me. There is a judgment of the Honorable Supreme Court in case of
Anup Senapati's case that has been dealt with in that judgment.
Anup Senapati's case.
That has
my
been
lord,
dealt with.
Their lordship held that once the granting aid order is repealed, it is repealed for all purposes. So benefit cannot be granted. That is my whole submission in a nutshell.
That has been reflected in para
letter, my lord, will submit after getting some time.
Para 4.24, your lordship may kindly see. Anup Senapati's case has been dealt with.
It may be dealt
in this
with.
judgment.
This is the ratio of that judgment.
No.
Once it is repealed, it is.
Well, it stands in a different footing.
That way.
Yes.
Well, it stands in a different footing.
That paragraph, that point is treated by which paragraph?
Paragraph 4.24.
Yes,
A further submission was also made, last 4 lines. A further submission was also made that this court, while disposing a similar batch of claim in the respect of high schools and colleges in FO number such and such, also clearly held that the decision in the case of Anup Kumar Senapati is not a complete bar to consider the extension of benefit under 94 order. Views expressed by this court in para 6.33 and 4. And in other paragraphs have also the same has been dealt with. In paragraph 3.4, your lordship may kindly see. That contention was raised by the State Council.
But
there is a grey area that since proposed in Anup Senapati's case, it has been held that since granting aid order of 1994 has been repealed, my lord, those who have not got the benefit as per the granting aid order of 94, they will not get. But there is a paragraph in the Anup Senapati's case that where proposals have been submitted prior to repeal of the granting aid order of 1994.
Treated as if that is not repealed.
Yes.
Well, that amounts to invoking section 6 of the General Clauses Act.
Yes, General Clauses Act.
How you are invoking that? That is not the act at all.
My lord, here, my lord.
It's a notification. It's in the nature of delegated legislation.
Delegated legislation. Your
application was not pending.
No, our application was, my lord, our application was sent prior to repeal of the granting aid order of 1994 in 2004.
2004?
2004.
That is repealed on which date?
That is repealed on 5/2.
This is repealed on 6/10/2000.
No, not 7. 5/2/2004.
5th February 2004.
5th February 2004. The proposal was sent earlier.
Which date you had sent?
My lord. Yes, that is there. Your lordship may kindly see that.
In other words, repeal is prospective in operation. All applications that were made when the order was in obtainment has to be treated.
Yes.
As if order was there.
Yes. So my submission before your lordship is, and so far as girls' high schools are concerned, here admittedly proposals were sent prior to repeal. And my second plank of submission before your lordship is, well, these schools were in fact notified to receive granting aid with effect from 1/6/1994. Otherwise, they would not have given all other benefits from 1/6/1994 to these 100 girls' high schools. Because accepting granting aid all other benefits, notional increments, pre-revised scale have been given to the schools as per the amendment order of 2007. They are only claiming grantee as per the grantee order of 1994, and large number of girls' high schools, out of 100 girls' high schools, they have got that benefit. They have been favored with that benefit.
But see the proviso. It
Yes.
is wrong.
Yes.
Proviso to repealing paragraph.
Well, the saving clause. Saving clause.
What is saved is
Yes.
only the institutions that are
Which are in receipt. Which are in receipt.
If
Which are
they intended that pending application are also saved, they would have made a provision which will appear in section 6.
Yes.
But that's what he says now.
But in Anup Senapati's case, there is a clear-cut paragraph. And it should be settled. Anup Senapati.
Which are in receipt of granted from the.
They
are saved.
They are saved.
Not application.
They are saved. They are saved. They are
Pending of application.
Otherwise,
they are not saved.
it amounts to
Yes.
interpreting, because this is a delegated legislation.
Delegated legislation.
Interpreting the delegated legislation with over-inclusiveness,
Yes.
which court cannot do.
My lord,
How that is treated by the other Anup Senapati?
my lord, your lordship may kindly see paragraph 31, Anup Senapati's case. That is relating to a college. College granted order of 94 and 2004.
Almost same. Right?
No, perimetry, no, there is a different provision in 2004 order. Your lordship may kindly see para 31. Page 41.
Para 31.
Page 41. It is apparent on consideration of paragraph 4 of order of 2004, that is college order, that only saving of the right is to receive the block grant, and only in case grantinate had been received on or before the repeal of the order of 2004, it shall not be affected, and the order of 94 shall continue only for that purpose, and no other rights are saved. Thus, we approve the decision of the High Court in Loknath Behra Supra on the aforesaid aspect for the aforesaid reason mentioned by us. Then, my lord, in another paragraph, that pending application, my lord,
they do not say pending application at all.
My lord, there is a paragraph. There is a paragraph. Your lordship may kindly see that. Well, that's so far as Anup Senapati's case is concerned, well, all applications were filed after they received block grant from the state government. That is after repeal of the granted order of 1994.
No, they have done that is another thing.
Proposals were not sent prior to repeal of the granted order of 1994. Therefore, in Anup Senapati's case, it has been held that not a single proposal was found prior to repeal of the granted order of 1994, and all those cases were filed after they availed block grant and after so many years of receipt of block grant. By taking that clue from that judgment of Anup Senapati's case, these two judgments have been delivered by the coordinate bench.
Kindly come to para 24.
Para 24. Of Anup Senapati's case.
Anup Senapati.
That is right acquired or accrued.
Yeah.
It is apparent from the aforesaid discussion, that is
what is
unaffected by a repeal of a statute.
Right acquired
or accrued.
And not mere hope or expectation
of
liberty to
apply for acquiring a right. There is a distinction in making an application for acquiring a right. If under some repealed enactment, a right has been given, but on investigation in respect of a right is necessary, whether such right should be or should not be given, no such right is saved. Right to take advantage of a provision is not saved. After repeal, an advantage available under the repealed act to apply and obtain relief is not a right, which is saved when the application was necessary. And it was discretionary to grant the relief, and investigation was required, whether relief should be granted or not.
Kindly next page. This is very important. The repeal would not save the right to obtain such a relief.
The right of preemption is not an accrued right. It is a remedial right to take advantage of an enactment. The right of a government servant to be considered for promotion under repeal rules is not a vested right unless repeal provision contains some saving and has been violated earlier.
G is saying now.
My lord, there are
6.3.
No, most of the writers, like
yes.
Crawford on interpretation of statutes,
Yes.
Aaron Barak, the Supreme Court of Israel, he has written the purposive construction of interpretation of the statutes.
Yes.
He also is of the same. That apart, there is one federal court judgment by Lord Justice Goyal.
Yes.
He has said, where an enactment is repealed, unless the pending applications are saved that are made when the enactment was in force, all they commit legal suicide.
But there is one paragraph in that judgment.
Crawford is there. There is a Grace on Statutes.
Yes.
A famous book on the Sutherland on statutory construction, American author.
Yes.
They are roughly speaking.
Yes.
Maxwell also treats, but
yes.
for students.
Yes.
But Crawford, Grace on statute, Sutherland on statutory construction, they have taken. Even G.P. Singh has mentioned.
G.P. Singh.
G.P. Singh has mentioned about this. I remember having read the
in the
fifth edition.
Yes.
Fifth edition I had read. Thereafter I could not read. Thereafter it is updated by Honorable Justice Arade, now in Supreme Court. When he was Judge of Karnataka High Court, he has updated it. That and another Jain on administrative law. 2 books he updated, edited. Thereafter, unless, therefore, Section 6, General Process Act, do you have? This view appears to be the view of most of the colonial countries.
Yes.
Where statute is repealed and where a delegated legislation is repealed, effect is same.
Effect is same.
Effect is same. Unless the repealing provision
saves that right.
Enacts Section 6 of the General Process Act. Kindly read Section 6 of the General Process Act.
I have to.
From Google, can you take that?
I will definitely Section 6. What is going
My lords, this is General Clauses Act 1897 details the effect of repealing a statute.
General Clauses Act?
Yes.
You have.
It is same.
Same
perimeter.
Yes. Repealing a statute, ensuring that the repeal of an act or regulation doesn't revive any non-existent law, affect the previous operations or actions taken under the repealed law, disturb accrued rights and liabilities, or extinguish any incurred penalty or punishment. Effect of
affect
any right, privilege, obligation, or liability acquired, accrued or incurred under any enactment so repealed, or affect any penalty, forfeiture, or punishment incurred in respect of any offense committed against any enactment so repealed.
Such a provision is absent in the repealing order.
But one paragraph.
If they wanted, if they have simply said repeal, perhaps we would have jumped to from Section 6.
Yes.
Now, in addition to repealing, they have made a saving clause.
Yes.
Saving clause according to
those who are in receipt of
receipt. Unless they alone are saved.
Yes.
Unless you challenge very that proviso itself. This one argument. I do not know.
Yes.
I am just reflecting on what I have read years ago.
My lord, that paragraph has been quoted, my lord, in Ratnakar Mahapatra's case, your lordship may kindly see, by the same coordinate bench.
Requires deeper examination.
Deeper examination. We'll have to keep it to some other day.
Orissa General Clause Act 1937 is there.
Yes.
It is on par with 87.
Yes, yes.
Almost the same.
Perimetry provision is there. Let us see paragraph 10.
Here it becomes section 5.
Section 5.
Section 5. One is minus.
Section 5.
Where any Orissa Act repeals any enactment thereto made or hereafter to be made, then unless a different intention appears, the repeal shall not revive anything not in force or exist at the time at which repeal takes effect. Affect the previous operation of any enactment or repeal anything done, duly done or suffered thereunder. Affect any right, privilege, obligation, liability acquired, accrued, incurred under any act. Affect any penalty, forfeiture, etc. Talk to any investigation. So therefore, kindly see that it means where if any act, unless a different intention appears.
Different intention.
In the proviso, different intention appears, it is contingent. That is true.
Yes.
Where do you stand? Is needs to be examined.
Yes. Needs to be examined.
That does not appear to have been deeply examined by the coordinate benches. I have read only 3-4 judgments after my transfer was notified.
Yes.
And out of curiosity, I was reading how repeal is treated by judges of this court. I examined them. Beyond that, I will not say anything.
Let it come some other day. Yes.
Yes. But by your argument, I learned little law relating to granting aid, how it operates in your state, etc.
Yes.
Thank you. Yes. I have some orders to serve. So 5 minutes I am going to tell me. Some matters I have reserved also. All other unreached matters will be distributed. Okay? Any urgent matters, anybody?
No
urgency.
Item 19, my item is 19. After vacation.
After vacation. Wherever they want after vacation. Just give them.
Well, that's a review. And I'm seeing what he is mentioning. That is review against the order of a applicable.
That is nobody.
But it is not maintainable.
Yes.
That is maintainable. I will satisfy.
Lordship's judgment is there.
My lord, we are not in the court. No opportunity of hearing my it is saying. No. One another advocate was present. He is seeking time. Without recording our presence, the order was passed. Okay. That is my ground. Not on. So no opportunity of hearing was there.
Then let it be there.
Let it after vacation. Why you are holding?
You take him for a copy.
Move